Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina's hearing in docket number 2020-229-E, Dominion Energy of South Carolina, Incorporated's establishment of a solar choice metering tariff pursuant to South Carolina Code, annotated section 58-40-20. Let's take roll from the commissioners. Present here in the hearing room are Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually are Commissioners Thomas, Irvin, Williams, and Powers. Are there any preliminary matters we need to take up?
Chairman Williams, Taylor Spear from Alder Energy Systems.
Attorney Spear, go right ahead.
Thank you, Chairman. I have a personal conflict for childcare that begins at 5 p.m. this afternoon. I certainly don't want to interfere with these proceedings. I can have someone from my law firm file a notice of appearance today and come in and sit in after that time frame. However, if that's during cross-examination of a witness or during the closing argument that Vice Chair Belzer has suggested, that might be a challenge. So just would like to address that.
Okay, what time do you need to sign off?
5 p.m.
Okay, so if we go until 5, you will be able to handle your business?
That is correct.
Okay, we should be able to accommodate that.
Thank you very much.
Anything else?
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy. We have one preliminary matter that we would like to raise.
Yes, sir. Go right ahead.
Thank you, Mr. Chairman. There are points in time where matters will arise during an ongoing proceeding and difficult decisions must be made in response to those matters. And yesterday, such a matter arose during the course of this hearing, which causes me to rise before you today and make a request of you that I have never had to do in all my years of appearing before this commission. I respectfully request that Commissioner Irvin recuse himself from further participation in this proceeding based upon his lack of impartiality that was exhibited yesterday through the statements that he made to Dominion Energy witness Alan Rooks. As you know, under South Carolina Code Section 58-3-30B, the commissioners are bound by the Code of Judicial Conduct under Rule 501 of the South Carolina Appellate Court Rules. Canon 3 of the Code of Judicial Conduct requires that a judge shall perform the duties of judicial office impartially and diligently. And Canon 3E1 states, in pertinent part, a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned. During the course of the hearing yesterday, Commissioner Irvin made the following statement to Dominion Energy witness Alan Rooks before the company had concluded its case and prior to the South Carolina Office of Regulatory Staff presenting its case in chief. And I'm quoting in pertinent part, "Yeah, there's a market until you take it away." That's exactly right. There's a big market until you take it away, and that's what you're proposing we do, and I'm not buying it. I'm not buying it. And I'm going to tell you that I'm going to fight it because it's wrong. And it's wrong for all these 11,000 customers of yours that made a financial investment thinking that they would have a chance over time to save money, and you're taking that away. And so I just want you to know I'm not happy about your proposed rate. I don't think it's justified. And I'm going to do everything in my power to see that it doesn't pass. I just want to put you on notice because it's just not right. Those were the statements made by Commissioner Irvin before the company concluded its case and before any other party, including ORS, had begun presenting its case. He clearly stated that he intends to rule against Dominion Energy and ORS in this proceeding, and he has announced his decision before hearing all the evidence that is to be presented in this case. I'm making these statements, making his decision on the merits of the case, and announcing his decision to the parties and the other commissioners prior to the close of Dominion Energy's case, before any other party has presented their case in chief, and before all the evidence has been presented for consideration. Commissioner Irvin has demonstrated that it is reasonable to question his impartiality in this proceeding. This commission has not heard ORS's presentation of its case in chief, where ORS is also proposing an elimination of the cost shift similar to that of Dominion Energy, but which is a deeper elimination of the cost shift than proposed by the company. In light of Commissioner Irvin's statements that he is going to do everything in his power to see that Dominion Energy's tariff doesn't pass, then it follows that he will also be doing everything in his power to see that ORS's recommendation to implement a deeper cost shift elimination will not pass. The lack of impartiality that Commissioner Irvin has exhibited toward Dominion Energy equally exists, and arguably more so toward ORS, who represents the public interest in this proceeding, which was explained by counsel for ORS through her cross-examination of Mr. Rooks prior to Commissioner Irvin's dialogue with Mr. Rooks. Moreover, the Commission has not heard any challenge to the other party's case that may be conducted by Dominion Energy through cross-examination of the other party's witnesses. The commentary of the Code of Judicial Conduct provides clear guidance when situations like this arise. The commentary to Canon 3E1 states, under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless whether any of the specific rules in Section 3E1 apply. Commissioner Irvin has decided how he intends to rule in this proceeding before all the evidence has been introduced into the record. He has expressly stated that he intends to rule against the company in this proceeding, and by extension, will rule against ORS before hearing ORS's case. Moreover, Commissioner Irvin has stated that he will do everything in his power to see that Dominion Energy's tariff does not pass. Commissioner Irvin cannot sit in the dual role of adjudicator by deciding this case, as well as a prosecutor in this case, by stating that he is going to do everything in his power to see that the company's tariff does not pass. This is tantamount to arguing as a party proponent for those parties who do not wish to eliminate the cost shift that is at issue in this proceeding. Without knowing precisely what actions he may take, we can only presume that he intends to influence other commissioners to follow his lead of deciding this case before all the evidence has been presented. As I stated at the outset, the decision to ask a commissioner to recuse himself during the middle of a hearing is not an easy decision to make. Dominion Energy takes no pleasure in making this motion and wishes that it was not so. But the company, as well as the other parties, are entitled to a fair and impartial hearing under South Carolina law, and the public should have confidence in these proceedings. Based upon Commissioner Irvin's statements yesterday, he has demonstrated that he can neither be fair nor impartial in this proceeding as required by the Code of Judicial Conduct. Therefore, Dominion Energy respectfully requests that Commissioner Irvin recuse himself from the balance of this proceeding and take no further action in this matter, which would include not voting on the resolution of this matter and communicating with other commissioners in an attempt to influence their decision in this proceeding. Mr. Chairman, the company has also filed a written motion this morning setting forth these arguments. This concludes the company's motion. Thank you, Mr. Chairman.
Mr. Chairman.
Commissioner Irvin.
May I respond, please, sir?
Yes, sir.
Thank you. Mr. Burgess, I want to assure you that I can be fair and impartial. I do want to apologize to Mr. Rooks for our exchange yesterday. I became frustrated, and I think I owe him an apology, and I hope he will accept it, because you're right that this case has to be decided on the merits, the law, and the facts. And while I understand the reason for your motion, I can tell you that having been a judge for most of my legal career and now an administrative law judge on the Public Service Commission, I certainly understand the need for a fair and impartial determination. And I regret that I made the comment that I did to Mr. Rooks, but I can tell you that I'm prepared to listen to all the testimony and evidence in the case. And I will promise you that I can render a fair and impartial decision in this case. And therefore, I'm going to decline to recuse myself because I am convinced that I am able to listen carefully to all the testimony and evidence before making a decision. And so I don't know if Mr. Rooks is listening, but again, I do want to apologize for the exchange that we had yesterday. I've thought about it last night, and I owe him an apology, and I hope he will accept it. And so thank you for hearing me and ready to go forward with the case.
Mr. Chairman, this is Chad Burgess, and I want to start off by saying that Mr. Rooks is with me in this room. He has heard your apology, Commissioner Irvin. The company has heard your apology, and we accept your apology. However, there are things that were said that I don't think can be unsaid. And the question of impartiality has been raised by the company, and the company is of the opinion that it cannot receive a fair and impartial trial in this matter as long as you reside on the commission in this proceeding. And at this point, it's not Dominion Energy's decision. I think the public must have confidence in this proceedings, and it is imperative that a fair and impartial trial be had. And it's also imperative that decisions not be made prior to hearing all of the evidence in the record, which is what was stated to us yesterday. So that's my concluding remark. We certainly will accept whatever decision is made here. But again, our motion is that, Commissioner Irvin, that you recuse yourself.
Thank you, and thank you for accepting my apology. And please thank Mr. Rooks as well. You know, we do get carried away sometimes in the heat of battle, and it happened. I regret it. But I have a duty under the law and the canons to sit. And I'm convinced that I can be fair and impartial. I hope that time will bear that out. I'm going to listen carefully. I have read the pre-filed testimony and evidence. I've certainly not prejudged the case because we're not at a point where we can do that. We haven't heard all the witnesses. So with all due respect, I'm going to sit, and you protected the record for your client, and I respect that as well. And I'm ready to proceed, Mr. Chairman.
Mr. Chairman, I appreciate Commissioner Irvin making those statements. And again, in the interest of making sure that this record is full and complete, I just want to make 2 points. Commissioners are not involved in the battle that may be ongoing among the parties. The commissioners sit as a tribunal to hear all the evidence, just like Commissioner Irvin said, and to make a fair and impartial decision in this case. Commissioner Irvin stated that he had not prejudged the case, and I respectfully disagree, Commissioner Irvin. The statements that you made yesterday were very clear. They were unequivocal. And Dominion Energy left the hearing room yesterday knowing that you had made your mind up that you were going to vote against this tariff. And like I said in my motion, that vote would also extend to a vote against ORS. I have nothing further on this matter, Mr. Chairman. I think the record is complete with respect to Dominion Energy's opinion on this matter. And we're prepared to proceed unless there's anything further that you would like from me.
Anything else from anyone else? Office of Regulatory Staff? right, we're in recess until 10:30. Well, good morning, ladies and gentlemen. We're back in docket number 2020-229-E, Dominion Energy, South Carolina Incorporated, establishment of a solar choice metering tariff pursuant to South Carolina Code, annotated 58-40-20. Let's take roll. Here in the hearing room, we have Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Irvin, Commissioner Thomas, Commissioner Powers, and Commissioner Williams. Before we took a brief recess, we were presented with a motion from Dominion Energy.
Mr. Chairman, this is Commissioner Irvin. May I be heard?
Yes, sir. You have the floor.
Thank you. I've had a chance to review the motion filed by Dominion and reflect on the matter further. And I want to protect the integrity of the process in this proceeding. And for those reasons, I've chosen to recuse myself from further participation on this docket. I regret the exchange that I had with Mr. Rooks, and I appreciate him accepting my apology. But I'm going to man up and accept responsibility for what I did. And I'm not proud of what happened, but I can tell you that I care about this process. I think you can, those of you that work with me and appeared before me, know that I'm passionate in my work. And so my only regret is I won't be able to participate and have any input. And just for the record, I will not be involved in the deliberations. I will not be talking to my fellow commissioners or staff about this docket. I've fully recused, so I will not be involved going forward. And I want to thank everyone for giving me a chance to be heard. And unless there's anything further, I'm going to leave the proceedings as I've recused.
Thank you, Commissioner Irvin. Any more preliminary issues before we proceed?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. Yesterday, when I was talking with Mr. Rooks, I asked about some information that I've gone and looked for in witness Robinson and witness Everett's testimony. And I did not find what I was looking for, so I wondered about asking for a late file exhibit. Can you share with me how I might go about asking that of Dominion?
Ask and ye shall receive.
Okay, go ahead and explain.
Just ask for what you want, Commissioner Williams.
Awesome, thank you. Good to see you, Mr. Burgess. What I'm interested in is understanding a typical NIM customer from the customer's perspective. And I see you juggling, so I'm going to slow down. So what I'm thinking about is how does the typical NIM customer look at this? Whether they're residential or commercial, what is the expected cost? Not return on investment. You've given us a lot of good information there. Not the years it's going to take for a new customer to pay off, but it's more from the perspective of the current NIM customers. What are the choices that they're going to have when their circumstance expires, or when they are making a decision to put more solar on their roof, or whatever the decision, as well as what are new customers going to, what are their options? And what I understand is that the option will be the solar choice metering option, but there may be other options under the various residential and commercial rates. And I think folks want to see that. I appreciate seeing your head nod. So I'm asking for residential and for commercial. various rates. So on the commercial side, from what I understand, rate 31, rate 33, rate 34 might all be in play, and the solar choice metering proposal. I know it's not going to be as simple as what I'm asking for, but I think just some round averages that say we based it on this size system or this amount of, maybe not size system, that's not the right, but this amount of use on a monthly or on a peak kind of basis. Does that make sense?
Yes, ma'am. This is Chad Burgess for Dominion. Yes, ma'am. That makes perfect sense to us. I've written down everything that you've asked for, and we'll go to work and we'll prepare this late filed exhibit and get it filed with the commission.
Thank you so much.
Quite welcome.
The commission will reserve hearing Exhibit 8 for Commissioner Williams' requested late file exhibit. It will be hearing Exhibit 8. All right. Are there any more preliminary issues? All right. Let's take appearances this morning so we know who we have with us. Dominion Energy, South Carolina.
Good morning again, Mr. Chairman. This is Chad Burgess for the company, and with me today is Matthew Gissendanner as well.
All right. Alder Energy Associates.
Taylor Spear, appearing for Alder Energy Systems, LLC.
Frank Knapp, Jr.
I am here, Mr. Chairman. Thank you.
Solar Energy Industries Association.
Jeff Kirkendall for CA Commissioner.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever.
Yes, thank you, Mr. Chairman. This is Kate Mixon here on behalf of SAY CCL and Upstate Forever. And I also have with me here today David Neal, who has appeared pro hoc in this proceeding.
North Carolina Sustainable Energy Association.
Good morning again, Mr. Chairman. Jeff Kirkendall for NCSEA.
Vote Solar.
Good morning, Mr. Chairman. Thad Cully on behalf of Vote Solar.
Office of Regulatory Staff.
Good morning, Mr. Chairman. Jeff Nelson on behalf of the Office of Regulatory Staff.
All right. Thank you very much. Let's get started with Alder Energies.
Thank you, Chairman Williams. Taylor Spear on behalf of Alder Energy Systems, LLC. We present our witness to the commission, Mr. Donald Zimmerman.
Good morning.
Mr. Zimmerman, please take the stand and wait to be sworn in by the court reporter.
Mr. Zimmerman, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Good morning, Mr. Zimmerman. Please tell the commission who you are.
My name is Donald Zimmerman. I'm the owner of Alder Energy Systems.
Are you the same Donald Zimmerman that prepared under your direction 17 pages of direct testimony in this proceeding?
Yes, I am.
If I was to ask you all of those questions presented in your direct pre-filed testimony, as if you were on the stand today, would your answer be the same?
Yes, I would.
Mr. Chairman, I move that the pre-filed direct testimony offered by Mr. Zimmerman be entered into record evidence in this proceeding.
The pre-filed testimony of Mr. Zimmerman, the pre-filed direct testimony of Mr. Zimmerman will be entered into the record as given orally from the stand.
Thank you, Chairman Williams. Mr. Zimmerman, did you include in your direct pre-filed testimony 2 exhibits that were identified as DRZ-1, 1 through 2?
Yes, I did.
Mr. Chairman, I move that these 2 exhibits marked for identification purposes as DRZ 1 through 2 be entered into the record in this proceeding.
DRZ 1 through 2 will be marked and entered into the record as hearing exhibit number 9.
Mr. Zimmerman, did you prepare a summary of your direct testimony for the commission today?
Yes, I did.
Would you please read it to them at this time?
Absolutely. Good morning, members of the commission. My testimony is intended to assist the commission in establishing DESC's Solar Choice Net Metering Tariff for South Carolina's non-residential customers that complies with the Energy Freedom Act. My company, Alder Energy Systems, has been offering behind-the-meter solar solutions to South Carolina ratepayers for over a decade. We have seen all manner of behind-the-meter policy changes, from the SC DN PACE program to the utility rebates and incentives for net metering under Act 236, and now facing additional changes coming from this docket and others pending before the commission. Alder's clients are small businesses, commercial real estate owners, developers, manufacturing plants, municipalities, and other non-taxable entities like schools and hospitals. These organizations all wish to participate in distributed generation solar to the extent that is economically feasible and aligned with their sustainability goals. I hope to offer the commission a unique boots on the ground perspective and be the voice of non-residential solar customers that either have or will invest in customer generation. I'm an electrical engineer by trade, earned a bachelor's degree in electrical engineering from the University of Michigan, a master's degree in optics from the University of Rochester, and a master's of business administration from Columbia University. I've worked in the field of photonics for nearly 3 decades, hold 7 patents, and have earned a solar PV installation professional certificate from the North American Board of Certified Energy Practitioners. The South Carolina General Assembly passed Act 236 to ensure ratepayers continued access to solar energy in South Carolina. The law prohibits any policy that penalizes customer generators for participating in DG. In establishing DESC's Solar Choice Metering Tariff, I asked the Commission to consider both the legislative intent and the directives given to DESC for creation of the tariff. As part of the generic docket, Witness Robinson forecast an anemic growth for non-residential solar. That growth was projected using the existing NEM policy and not the proposed DESC Solar Choice Tariff. I believe that the non-residential solar industry will collapse in DESC territory if the Commission approves Dominion's non-residential Solar Choice Tariff. Of the many factors that influence solar adoption of non-residential solar, the 2 primary considerations are the economic benefit offered and the alignment with the customer's sustainability goals. One of the most useful measures of economic benefit that a solar adopter will use is payback. The time it takes for the cumulative benefits provided to the solar adopter to become greater than the cost. The economic benefit of DG is derived from consuming locally generated power at the full retail rate and exporting excess generated power for consumption at some other time during the netting period. The compensation for excess power, as calculated at the end of the netting period, is made at the value of solar rates, as determined by the generic docket. The payback interval for Alder Energy's DESC non-residential NEM customers averages 5.5 years. The average system size is 90.5 kilowatts. Alder Energy has found that the upper limit for non-residential solar adoption is a payback of 8 years, with 4 to 7 years being the norm. Additionally, many non-residential customers have sustainable energy goals that require them to retain the environmental attributes of their solar energy system. It's extremely important that those and all the customers retain the right to RECs, renewable energy certificates, that their systems produce. The proposed solar choice tariff features 4 different elements that, when taken as a group, will sound the death knell for future non-residential solar. Successful solar adoption depends critically on a payback period and ROI that is in line with a company's alternative investment opportunities. The average customer would have their payback periods extended many years, and in some cases beyond the useful life of the system with the new solar choice tariff. Larger system sizes, like one's Alder installs, tend to have longer payback intervals because of an increase in the generated power export. With the Dominion's proposed netting period, that exported power is compensated at the value of solar rate and not banked for future use. In other words, Dominion's proposed tariff is not net metering at all. You should also know a shorter netting period will inherently discourage larger investments in DG systems. The subscription fee that has been proposed by DESC is a discriminatory mechanism to claw back the value that a solar energy system provides when it reduces a customer's load. DG is consumed. All customers, solar or not, have a right to reduce their load without penalty. Just like an efficiency measure such as LED lighting or a new high-efficiency HVAC system, a solar project can reduce a customer load. The customer should not be penalized for this, and the subscription fee, unfortunately, is just such a penalty. In addition, accurate predictions of future solar benefits are not possible without hourly 8760 data of a customer's load. With the proposed hourly netted rate, one needs to be able to determine hourly net exports and hourly consumption before an accurate estimate of bill savings can be made. Without performing these calculations, the estimates of production can be manipulated by unscrupulous solar providers. This is a consumer protection issue that must be considered before the solar choice rate is adopted. In summary, an unfavorable decision from the Commission in this proceeding is likely to elongate the payback period and reduce a system's return on investment, and thereby disrupt or even damage the DG solar market in the DESC territory. Merely maintaining the existing scale of DG deployment for C&I customers in DESC territory will depend heavily on the Commission providing policies that do not extend the payback period. Expanding the existing scale of DG deployment for non-residential customers in DESC territory will be highly unlikely without the Commission's approval of a continued one-for-one bill credit for non-residential customers that allow annual accumulation of energy credits. Alder Energy recommends the Commission approve a tariff that balances continued access to economically viable solar with any potential cost shift to non-solar ratepayers, allows for full retail compensation for load reducing DG consumption without subscription fees, maintains annual netting or at a minimum monthly netting, does not permit time of use rates until 8760 data is available, and provides that the RECs associated with distributed generation are provided to the customer. Thank you for your attention and your consideration in this important matter.
Thank you for your summary, Mr. Zimmerman. Are you also the same Donald Zimmerman that prepared 6 pages of Sir rebuttal testimony in this proceeding?
Yes, I am.
And you pre-filed that Sir rebuttal testimony, correct?
Yes.
If I was to ask you all of those questions present in your pre-file Sir rebuttal testimony again under oath today, would your answers be the same?
Yes, they would.
Mr. Chairman, I move that the pre-filed surrebuttal testimony of Donald Zimmerman be entered into the record as if given orally from the stand.
The pre-filed surrebuttal testimony of Mr. Zimmerman will be entered into the record as if given orally from the stand.
Chairman Williams, Alder Energy will not be offering a summary of their surrebuttal testimony. So at this time, I open up Mr. Zimmerman to cross-examination from the parties as well as commissioner questions. Thank you.
Frank Knapp, Jr.
Thank you, Mr. Chairman. I appreciate the opportunity to speak with Mr. Zimmerman. Mr. Zimmerman, good morning.
Good morning, Frank. How are you?
I am doing just fine. In full transparency, Outer Energy is the solar company that I used for my 2 commercial installations. Is that correct, Mr. Zimmerman?
That is correct.
But you and I have never, ever officially met in person, have we?
No, we've spoken on the phone, but not in person.
Okay, very, very good. I just wanted to make sure we understood that. And there has been no arrangement for me to be asking you questions that you might find favorable for any of our business arrangements. So there's been no offer of any type of inducement.
No, absolutely.
Okay, but just wanted to make sure. Thank you. Mr. Zimmerman, did you hear Commissioner Williams asking for some more information from Dominion regarding the solar choice tariff, about all the choices that were going to be available to existing customers and to new customers, both residential and commercial?
Yes.
I'm glad that was asked for. That is important. She is absolutely correct. But let me ask you this: if they provide this new exhibit and it lists all these choices, and we've heard from other witnesses, they've gone through what those choices are going to be. Are those choices on paper meaningful if the customer does not have that hourly data to plug into each option?
Without having the hourly data, they certainly cannot evaluate the solar choice option. With the consume all, I'm sorry, not the consume, the consume all, they would also need to have that hourly data to know how much they would be exporting. So yes, I agree with your assessment that they need to have the hourly data in order to determine what the economic benefit would be.
So just having a list of the choices really does not help the existing customer or the potential new customer.
Correct. That is right.
All right. They're an important step toward educating an existing or new customer, but they are not everything that is needed.
Yes. There's a very good question that was asked as to what would be the default for an existing customer. That clearly needs to be understood. But yes, in addition, we have to have the hourly data to assess the financial viability of any proposal.
And as my solar installer and the company that I would turn to for help in understanding my options, do you have that information on the hourly information on my particular account to tell me how the solar choice tariff will impact me?
I do not have that, no.
And if you don't have that information to tell an existing customer, is that going to impact the way your sales force, because I don't know that you actually are in the sales part of your business, and how they are going to talk to potential new customers and help them determine whether they want to engage in your services or your company?
It's a very difficult problem to deal with because, you know, we want to be honest and truthful and provide an accurate representation of what a system can do. And I don't believe that we can do that without that hourly data.
Well, you just used an interesting terminology. You want to be honest in what you do. The solar industry has some problem, does it not, with possibly some companies not being so upfront with honesty, with trying to entice people to engage with solar net metering?
Unfortunately, there is that reputation. I'd like to believe it's just a few bad actors. Certainly, from the moment we got in this business, that was a hallmark of what we stood for. Good, bad, or indifferent will give you our accurate and most honest representation of what a system can do for you. And if it works for you, great. If it doesn't, then, you know, we part friends.
Without the data that you need to be honest with a customer to give a good degree of certainty of their savings if they invest in a solar, rooftop solar, are you not, would this, as it's stated now in the solar choice tariff, essentially be maybe turning over the market, a solar market, to those who are willing to not be so honest in approaching customers?
We have not determined what we are going to do as of yet, because it is very much dependent on whether this tariff goes forward or not. But it is highly likely that if this tariff goes forward due to other reasons, such as customers not interested in the payback period, we will probably have a difficulty in selling anything into the market.
And possibly the units that installation that are being sold, they're being sold to customers who want to believe the person who says they're going to save a lot of money, even though they cannot do so with certainty.
More than likely, they would be over-promising or stretching the envelope.
Okay. Thank you for that. Were you watching or listening when Witness Robinson was testifying?
Yes.
I had asked Witness Robinson of the company Guidehouse, that was the company that did the solar PV forecast for Dominion, about the importance of payback. And you discussed a little bit that in your direct testimony. And the question was, how important was payback in the customer's decision-making process? And he responded something to that while payback was used quite a bit in that decision-making process, payback was not a good metric for predicting decisions. Do you agree?
If you are a TFO, you might not use payback, but most of the people we are speaking to use payback as a simple method to compare their investment in solar to the other investment opportunities they have. Take, for example, a manufacturing plant. They could go install another manufacturing line, and the cost to do that would have an anticipated payback, or essentially a break-even point. And after that, it would be cash flow positive. And that's the way most people are. That's the simplest way for people to look at the investment, and it's the easiest discussion to have.
So most of the people you deal with are not CPAs. they're not
they're not economists, they're not CPAs. A lot of the times they're building managers or or business owners even, that they understand the value of cash.
Thank you, sir. I think you just described me. Okay, Mr. Robinson also stated that the solar market is growing or expanding if, and I use this example, if only one new solar system is added. Do you agree? Is that the sign of a growing, healthy market if our criteria for saying something is growing is that there's one more being added compared to last year?
I wouldn't consider that a healthy market. It I guess by the definition would be a growing market.
Okay, thank you. Okay, and one last thing, I want to go back to existing customers, whether they be small commercial or residential. I had asked witness Everett if she could tell me what the impact to me and my savings would be if I immediately went under the solar choice tariff. And her response was, no, she could not look at a current bill and tell me that. Do you agree with that?
We could not, yes, we could not, I don't think anybody could give you an accurate representation of what your cost or financial benefit more than anything else would be using only monthly bills. The new rate has time of use aspects in it, both in the netting period as well as in the consumption and load offset that have hourly dependency. And a monthly bill would not provide enough information to give anywhere near an accurate response.
And I just thought of one other thing, sir. In your marketing for your company, how much do you rely on being able to point to a similar situated customer of yours and using them as an example of how they are going to benefit from engaging in rooftop solar?
Every customer has an independent analysis done for their situation. Every rooftop has a different orientation, which changes the productivity of the solar. Every project has a different cost associated with it, depending upon mounting schemes, inverter choice. And so therefore, when we provide a proposal to an individual, it is highly customized, and using others people's data is not done.
Okay.
Yeah.
That's fair. In regard to word of mouth advertising, we also hear that is the best form of advertising, when an existing customer says to other people what a great product or service this is. Is that important to Outer Energy?
It absolutely is. It is the most important mechanism we have for attracting customers.
And what is it going to do if I cannot relay from my experience to a potential new customer how much I benefited if I know full well that that new customer is not going to benefit to the same degree I am because I'm under a different solar net metering program?
I think at that point in time, you can't attest to the financial viability of the project. Hopefully you can attest to our ability to perform and our interactions. But certainly your experience will not necessarily be a Solar Choice customer's experience.
All right, very good. Mr. Zimmerman, thank you very much for your time. No more questions, Mr. Chairman.
Solar Energy Industries Association.
SIA has no questions for this witness, Mr. Chairman.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever.
Thank you, Mr. Chairman. This is Kate Mixon. We have no questions for this witness.
North Carolina Sustainable Energy Association.
Similarly, Mr. Chairman, we have no questions for this witness.
Vote Solar.
Thank you, Mr. Chairman. I'm going to break the streak. I do have some questions for Mr. Zimmerman. So, good morning, Mr. Zimmerman. How are you today?
Doing well, Mr. Cully. How are you?
Very good, thank you. Now, I'll just recap very briefly. We had a conversation in the generic about your business and about the policy history of South Carolina. Do you agree with that?
Yes.
Okay, so I don't want to go back over all of that, but I do want to focus on one moment in time, and that is before Act 62, and particularly in regard to net metering caps. Are you familiar with? You're familiar with the net metering caps that were in Act 236?
Yes, the net metering caps, correct? Yes.
And in your summary of your direct, I think you said Act 236. Did you mention Act 62 in terms of the intent to continue to build on?
I mean, Act 236 was part of the history I was enumerating in our experiences of being involved in that. Act 62 certainly, one of the stated goals is to continue the successful adoption. I may have misspoke.
Oh, no problem. I just wanted to make sure the record was clear on that.
Okay.
With Act 236, were you aware that with passage of Act 236, more steps needed to happen before net metering became active? And in particular, I'll ask you, are you aware that the utilities had to file distributed energy resource program proposals and to have those approved for net metering to become available?
Yes, I believe that that's the case.
And were you involved in the process of implementing Act 236? And were you at least on the periphery of those negotiations and kind of hearing that this was happening?
I had participated in a couple of stakeholder reviews, but I wasn't intimately involved in any of the legislative activity that took place.
Okay. With Act 236, the settlement that established net metering and this net metering methodology that's been discussed throughout the hearing, were you familiar with the terms of that settlement after it was filed and ultimately approved?
Yes, I was.
And you would need to be familiar with the terms of that settlement as a business owner that's in the business of selling solar facilities to customers.
Correct.
And it's been discussed that current customers are grandfathered. Now, to you, does that mean that they've locked in a specific per kilowatt hour rate that they're going to get paid for all power they put to the grid? Is that your understanding of what grandfathering means?
My understanding of grandfathering means that the structure of the rate is not going to change. The individual per kilowatt hour numbers would probably change through rate case, discussions.
So if a rate case were filed before these grandfathering rights expire, you would admit that these existing customers could see their rates change from where they are today.
I believe that's the case, yes.
But is it also your understanding that their rates would change only to the extent everyone else in their class also sees those changes?
That is correct.
So there's no discrimination or differentiation between customer generators and the rest of the class currently?
That is my understanding.
Okay, thank you. Now, let me ask you, this has come up several times, and Mr. Knapp kind of raised this as well, this idea that there were some other options that have been discussed in this case. One was a buy all, sell all. Now, have you ever installed a system in the state of South Carolina, not just in Dominion's territory, but in the entire state, where you engaged in a buy all, sell all for a system located on the customer's premises?
Yes, we have. That was a predication of the BCA, the Bill Credit Agreement, which was the commercial incentive offered by Act 236. It was a sell-all arrangement where all the energy from the generator would be connected directly to Dominion, and the customer would be credited on their bill a fixed tariff, fixed fee. And then, their consumption was through their normal metering and normal rates.
Now, would you agree with me that the bill credit agreement, that was based on a fixed per kilowatt hour rate over a period of time?
Yes, I believe it was guaranteed for a certain period of time. I believe it was 10 years. I mean, without seeing the rate, I'd have to validate that. But and then it scaled in terms of dollar amount by system size and class. For instance, municipalities and schools and churches got a higher rate than a commercial enterprise.
And would you agree that because the customers were not consuming any of that power behind the meter, this was part of the DER program that was approved in 2015?
Yes.
And this was an incentive to install a certain amount of solar. Was there a cap on that program?
There was a limitation on it. I don't remember if it was a megawatt cap or a time cap, but it had a very short window.
And would you agree that the bill credit arrangement credit that locked in for customers was in excess of what it cost?
Yes, it was.
And by a large amount?
Yes, it was.
And that difference between avoided cost and the bill credit agreement or arrangement rate, was that a DER program cost that's recovered through this monthly charge we've discussed in this case?
Yes, I believe that's one of the recovered costs in that program.
And that's one example of a non-net metering charge that is in that rate that is continuing to accrue.
Correct.
Okay. And you would agree that no one in this case has advocated to upset the Act 236 agreement?
Yes, I agree that is not on the table here.
So to the extent Act 236 and the settlement created a situation where there were incentives paid that are going to be collected from all ratepayers, would you agree that is a cost that is being put on other ratepayers?
Yes, it is.
And have you reviewed Act 62, this Chapter 40 we've been discussing at great depth the last few days?
Yes.
And are you aware that Act 62 specifically mentions the order adopting the net metering settlement from 2014?
Specifically mentions the order. I'm sorry, restate the question, please.
Oh, yeah. I'm just saying, are you aware that the statute, the current solar choice metering Chapter 40 statute, makes specific reference to the commission order that adopted the net metering settlement?
I believe it did. That was not my focus of reading of that docket.
Understood completely. I guess the point I'm trying to make is it your understanding that Act 62 created a window between the adoption of Act 62 and June 1st of this year, where customers could come in and enroll under the same terms provided under the Act 236 settlement?
Yes, that is my understanding. Correct.
Okay. And as we've agreed, the Act 236 settlement provides for a charge that is socialized among all customers.
Yes.
And would you agree that if the legislature were being absolute in their resolve to eliminate all cost shift to the greatest extent practicable, they may not have extended the terms of that agreement that allow cost recovery?
Yeah, that certainly would be an option, and I would agree with your view.
And unlike Act 236, would you agree that Act 62 removed any cap on how many customer-generator systems can be installed in any utility's territory?
Correct.
Okay. And are you generally familiar with the press that was happening at the time about what the intent of this bill was?
Yes, I vaguely remember some of that, yes.
And are you aware that Governor McMaster held a ceremonial signing of Act 62?
Yes, it was hailed as the next step in solar adoption in the state and something to move solar forward.
Okay, Mr. Chair, at this time, I'd like to introduce a cross exhibit. I'm going to email to the parties right now. And for your reference, Mr. Chairman, this has been pre-marked as Vote Solar Zimmerman Cross Exhibit number 1. And I'm going to share screen.
All right. Hey, do me a favor and give us a little time to distribute that exhibit in the hearing room.
Thank you.
Alrighty.
Okay, thank you, Mr. Chairman. So as I was saying, this is exhibit pre-marked as Vote Solar Zimmerman Cross Exhibit number 1, identified as the Twitter post of Peter McCoy at 11:04 a.m. May 22nd, 2019. I'd move that this be admitted to the record as the next hearing exhibit.
Vote Solar Zimmerman.
Mr. Chairman, this is Chad Burgess for Dominion Energy, South Carolina. Before we admit a tweet into the record that's not done apparently by Mr. Zimmerman, I think I'd like to know a little bit more about what the tweet actually says. I don't have Mr. Cully's exhibit in my inbox just yet.
Oh, thank you for letting me know that.
Apologies, Mr. Burgess. Please do let me know when you receive that. I know I did send it a few minutes ago.
It's out there in cyberspace. If you want to scroll down in the interest of time, that would be fine.
Sure. So before this is admitted, I'm just going to give you a preview, Mr. Burgess. And make sure I might have to minimize so we can get the entire thing on here.
Okay.
Even further, sorry about that.
Okay, I can see that, Mr. Cully. Okay. All right.
Okay, thank you.
So Mr. Chairman, I think you know what I'm about to do, but I'll let Mr. Cully lay his foundation before I jump in here.
Mr. Cully, try to lay your foundation.
All right. Mr. Zimmerman.
Mm-hmm.
So first, let's just start off. You're familiar with this Peter McCoy character, are you not?
Yes.
Are you familiar? He's been in the news quite a bit the last week.
Mm-hmm.
Now,
hey, Mr. Cully.
Yes, Mr. Chairman.
I understand. I'm sure you didn't mean anything by calling. Is it the 28th yet? South Carolina's U.S. attorney a character, but if you would just refrain from any name calling.
No, my apologies for being too familiar. I have a tremendous amount of respect for Mr. McCoy, a great deal of warmth for him personally. So my apologies for being way too familiar. Please accept my apologies.
Proceed.
Mr. Zimmerman,
Mm-hmm.
are you familiar with Peter McCoy as the sponsor of Act 62 or the House version in 2019?
Yes.
Now, did you follow Mr. McCoy's, Representative then McCoy's, Twitter accounts and public announcements about Act 62 as a member of the solar industry interested in this?
I don't do Twitter. but I have been, I did follow him in the newspaper and through various email exchanges.
Okay, and have you ever seen this picture presented in Governor McMaster's account's tweet?
Not in his tweet, no.
Okay, well,
I have seen the picture, though. To your point, it was emailed to me. I don't remember by who.
okay. Well, you know what? We're just going to move on. Not everyone is a fan of Twitter, and I'm going to move to the next point. So, you know what? I think I've covered everything I need to cover with you, Mr. Zimmerman. I really do appreciate your time, and I have no more questions for this witness.
Thank you, sir. Office of Regulatory Staff.
Office of Regulatory Staff has no questions for this witness. Thank you, Mr. Chairman.
All right, Commissioner questions. Oh, I'm sorry.
Mr. Chairman.
I forgot about the applicant.
That's quite all right, Mr. Chairman. I was going to remind you but you stopped yourself. Thank you so much for doing that. Mr. Zimmerman, good morning. My name is Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina. How are you today, sir?
Good morning. Doing well. Thank you.
Great. I just have a few questions for you. I want to start off by asking you, in your summary, I thought I heard you reference the phrase knell. Did I hear that correctly?
Death knell, correct.
Death knell, okay. And would you please point me to where that shows up in your direct testimony or in your server rebuttal testimony? I believe I may have missed that when I reviewed your testimony.
I'm not sure I used that particular phrase.
Okay, so we can agree that that statement was not in your direct testimony, correct?
I don't believe so.
Thank you, Mr. Chairman. And since it wasn't in your direct testimony or in your server rebuttal testimony, and I'm sorry I don't have a copy of the summary that you were reading from, would you mind grabbing your summary there and reading what you had said about the death knell?
I need to find it here.
Take your time.
All right, here we go. The proposed solar choice tariff features 4 different elements that, when taken as a group, will sound the death knell for future non-residential solar.
Okay, thank you, Mr. Zimmerman. And non-residential solar, that is your line of business, is it not?
That is correct.
Okay. And you understand in this docket that the possibility exists that the solar choice metering tariff that the company has presented might be approved by the commission. You recognize that's a possibility, correct?
Yes, that's correct. That's why we're here.
You also recognize, well, have you read the testimony of ORS witness Brian Horry?
I have read portions of it and had other portions of it summarized for me.
Okay, very good. And do you understand the recommendations that Mr. Horry is presenting to this commission on behalf of ORS?
Not in detail.
Would you agree with me that ORS is proposing a deeper cost shift elimination than what Dominion Energy is proposing in this docket?
Attorney Burgess, excuse me, witness Zimmerman. Attorney Burgess, for some reason or another, you trailed off there.
Okay, I'll repeat my question, Mr. Chairman.
Thank you.
Mr. Zimmerman, I had asked you whether or not you had read Mr. Horry's testimony, and I think you indicated that you had read some of it, and you had other portions of his summary testimony read to you or provided to you in some sort of summary fashion. Did I hear your answer correct?
That was what I said, yes.
Very good. And I further ask you, were you aware or are you aware that ORS witness Brian Horry is proposing recommendations to Dominion Energy's solar choice tariff, which, if enacted, would result in a deeper cost shift elimination than that which is being proposed by Dominion Energy in this docket. Do you understand that?
What it was represented to me is that it is different than yours. It didn't I was not given any information on directionality.
Okay. Would you be surprised to learn that witness Horry is recommending a deeper cost shift elimination than was being proposed by Dominion Energy, South Carolina, in this docket?
That's your interpretation. I really don't have a basis for forming an opinion.
I didn't ask you for an opinion, Mr. Zimmerman. I just asked you if you would be surprised to learn that.
Nothing surprises me.
Okay, understood. Mr. Zimmerman, the death knell that you referenced, would your company be included in the fallout, if you want to call it that, with respect to the DESC solar choice tariff?
It is highly likely, if your tariff as presented goes through, that we would be part of the so-called fallout.
And you understand, well, I think I heard you say that you're familiar with Act 62, which is the reason we're here with respect to the solar choice metering tariff. Did I hear your testimony correct on that?
Yes.
Okay. And you understand that this commission is required to implement a solar choice tariff for customers who present applications after May 31st, 2021, correct?
Yes.
And so we're roughly, by my count, Mr. Zimmerman, and you can correct me if I'm wrong, we're roughly 90 days away from the possibility of a new solar choice tariff coming into in existence, are we not?
Yes, that is a possibility.
Okay, and you stated earlier that you think that your company would be caught up in that death knell. My question to you is, Mr. Zimmerman, what actions have you taken to protect your company from being caught up in a death knell by May 31st, 2021?
My company operates in many different areas within South Carolina and outside of the state. More than likely, if the solar choice tariff goes into law and into action the way it is written, there will be no market left for us to engage in, and we will have to leave the market. That doesn't mean my company will die. It doesn't mean it will mean one of our lines of businesses will no longer be viable.
Understood. So your company will survive regardless of what this commission decides in this docket. Is that your testimony?
My company will have to make a major pivot. A large part of our revenue had come from DESC territory. So it will probably not survive in its current capacity.
I'm a little confused, Mr. Zimmerman. I thought you said that your company would survive, and now you're saying that it would not survive in its current capacity.
Yes, we'd have to make some changes.
Okay. But your company would nonetheless still be in existence, would it?
I believe that's true, but we would not be operating within DESC.
Okay, very good. Mr. Zimmerman, let me get you to turn to your direct testimony. Do you have that handy?
My direct?
Yes, sir, your direct testimony.
Okay, yep, you got it print out.
Okay, very good. Would you turn to page 12, line 15?
Line 15, okay.
And I'm going to draw your attention to the
just for clarity, page 12 on the side or page 12 on the bottom?
Oh, thank you, Mr. Zimmerman. Yeah, I'm looking at page 12 on the sign. That would be page 11 at the bottom. Yeah, thank you.
Okay, thank you.
All right, very good. On line 15, are you with me?
I got it.
Okay, very good. At the very end of line 15, it states, however, your testimony states. However, the rightful default ownership of RECs, which is a renewable energy credit, resides with the customer generator, which is often a lessor of the system. Did I read that correctly?
That is what is here. Yes, correct.
And is it your testimony that the REC, again, that's a renewable energy credit, is it your testimony that the REC should reside with the customer generator when they are supplying energy behind the meter?
Well, it is my testimony that the REC should reside with the customer generator for all generation that it produces.
Okay. So in response to my question, we'll just take it one step at a time. I want to make sure the commissioners understand the REC that's generated when a customer produces power and that power is consumed behind the meter, the REC would reside with the customer generator, correct?
Under which plan, sir?
Not a trick question, Mr. Zimmerman. I'll repeat it. The customer generator, when they produce power that is consumed behind the meter, I thought I heard your testimony to be that the renewable energy credit that is produced as a result of that resides with the customer generator. Is that correct?
Well, I believe I've stated that the rightful ownership for all customer generation should reside with the customer generator, the owner of the system.
Understood. And you understand that there's two components to net metering. There's a piece of net metering where the customer consumes power behind the meter. That's one piece, correct?
Yes.
Okay. And there's a second piece as well, which is when the customer generator actually exports power to the DESC grid. Is that correct?
Yes.
Okay. I'm just focusing on the power that the customer generator consumes behind the meter. And it's your testimony, is it not, that the renewable energy credit resides with the customer generator for that specific energy component?
It is my testimony that the renewable energy credit should reside with both portions, both consumption and export.
Fair enough. I understand exactly what you're saying, Mr. Zimmerman, and I'm just wanting to make sure that the commissioners understand this concept as well. So in addition to the REC residing when a customer consumes power behind the meter, it's your testimony that when the customer generator exports power to Dominion Energy South Carolina, that the REC is retained by the customer generator, correct?
I'm saying that the REC should be maintained by the customer generator.
Understood. And you understand the importance of a renewable energy credit, do you not, Mr. Zimmerman?
Yes, I do.
And you understand that when the renewable energy credit is decoupled from the power that a renewable energy facility creates, that's no longer green power. You understand that, correct?
Well, what I understand is that our clients, our customers, some of them have renewable energy goals, and they would like and are paying for the RECs for all production on the system.
And you understand, do you not, Mr. Zimmerman, that when you decouple the REC from the power that's exported to Dominion Energy System, that power is considered brown power. You understand that, do you not, sir?
I don't use the term brown power or green power. I really don't know what the definitions of those are.
Well, you would agree with me, would you not, that that definition is important because we're talking about renewable energy facilities under Act 62, correct?
We are talking about renewable energy facilities. We are. I mean, whether green power or brown power, I don't believe is in any of the definitions. I have heard some testimony where people talk about green power and brown power. I haven't had it defined. It's a new term to me.
Mr. Zimmerman, how long have you been in business?
In business in the solar industry?
Yes, sir, in the solar industry.
We started in 2008, so that would be about 12 years to
12 years.
10 years.
And you're telling this commission that this is the first time that no one's ever defined green power to you?
With regard to rec ownership and consumption, green power, once again, I don't understand the significance of that definition. If you would like to sit here and tell me I'm an idiot, go right ahead.
You understand, do you not, Mr. Zimmerman, that Dominion Energy is paying an avoided cost? Well, today they're actually paying a flat rate tariff for the power that is exported to their system. Do you understand that?
Right now, there is a docket which values the value of solar. My understanding, that value of solar docket will define what the compensation is for exported energy. That's my understanding. What ends up in that value of solar docket is what will define whether the renewable energy credits are contained in that export or are not.
And Mr. Zimmerman, do you understand when the REC is decoupled from the energy that is produced and exported to the DESC system, that is no longer considered renewable energy?
Chairman Williams, Taylor Spear for Alder Energy.
Yes, counsel.
Objection, asked and answered.
Sustained.
Mr. Zimmerman, you've made a recommendation in your testimony that we just covered that the renewable energy credit should reside with the customer generator regardless, correct?
Yes, that is the gist of what I've said.
And you're making a recommendation based upon, we'll strike that, notwithstanding that recommendation, you're making it even though you do not understand green power and have no knowledge of its treatment on the DESC system. Isn't that correct?
I do not have this pure definition of green power. I understand the concept of green power, but I don't have a definition, and I don't know what exactly the relationship is between power generated on a DG system and the REC continuance. And that's really what you're getting at. And you already answered that question.
And the understanding that you just referenced, or the lack of understanding that you just referenced, is the basis for your recommendation, is it not?
You've made a contention that any REC must stay with the energy. I am unaware that that is the case. My understanding is the REC can be assigned to anyone.
Thank you, Mr. Zimmerman. I have no further questions of this witness, Mr. Chairman.
All right. Thank you, Mr. Zimmerman. We got commissioner questions, but now is a good time for a lunch break. We're in recess until 1 o'clock. Good afternoon, ladies and gentlemen. Thank you for joining us here at the Public Service Commission of South Carolina in docket number 2020-229E. This is Dominion Energy South Carolina Incorporated's establishment of a solar choice metering tariff pursuant to South Carolina Code annotated section 58-40-20. Before we proceed, let's take roll. Here present in the hearing room are Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually are Commissioners Thomas, Powers, and Williams. Before we broke for lunch, I believe the applicant concluded cross-examination. Now it's time for Commissioner questions.
Mr. Chairman.
Vice Chair Belzer.
Thank you. Good afternoon, Mr. Zimmerman. Thank you for your testimony.
Hello, how are you? Thank you.
I'm fine, thank you. I just have want to talk about a couple of matters with you. In your testimony, and I thought I had it marked, but I have in my notes, you stated with regard to the proposed subscription fee, I believe it was in your sir rebuttal testimony, that there was no causal relationship between the distributed generated the DG system size and demand on the grid. Can you elaborate on that statement for me?
Yeah. It was intended to read causal, no causal relationship.
I can't read my own handwriting.
Okay. And what I meant by that was that for instance, size of the service that the customer required would not increase by the installation of a DG system. So in other words, the maximum load a customer would have would be when the DG system was not operating. That would be the same. And in terms of export, the maximum export that the DG can provide is the maximum size of the inverters on the solar project. That will always be smaller than the customer's demand, contract demand in the commercial space, based on sizing requirements, interconnection guidelines. So the point is, there is no additional infrastructure cost required to put a DG project on an existing customer.
Well, as I've read through some of the other testimonies, I know it was in, I believe it was in witness Horry's testimony for ORS, and I believe in Dominion's witness also. Did you go through any of these other testimonies? Did you see where there was language that indicated that the subscription fees are designed to reflect or recover the transmission and distribution costs for residential customers, and the transmission and distribution costs, I think, net of avoided cost for the small general services? Do you dispute that?
No, I've seen that, certainly.
But you disagree with that?
Well, I believe that the subscription fee is intended to make up for the lost revenue that the company would experience from a DG generator consuming solar power on site.
Okay.
Very similar to, an energy efficiency or retrofit like LED lighting or HVAC.
Okay. In your sir rebuttal testimony, I'm jumping around a little bit, and I apologize for that, but it's just the way I have my notes. in your SIR rebuttal on page 5 of 6. And this is in response to SIR rebuttal, the SIR rebuttal to Dominion witness Cassis. But on lines 1 through 5, could you elaborate on those two sentences? Moreover, hourly netting would significantly reduce the economic value of a NEM solar energy system. DG system sizes would naturally be reduced to minimize the hourly exports.
Absolutely. I see that language. So what I mean by that is when you compare the existing program where you have annual netting, in other words, if I export to the grid today, that export is credited and I can use that power tonight, for instance. Okay, that would be, but those credits will exist for 1 year. And then at the end of that period, if there's any excess credits, they're compensated for at the value of solar rate. And
that's the current.
That's the current program.
Okay.
So what Dominion is suggesting is that they reduce that 1 year netting to 1 hour netting. So on every hour, the export that is accumulated in that hour would be compensated at the value of solar rate. In other words, there's effectively little or no, what's the term they've been using? Banking going on, right? So if I generate a little excess this hour, I can't use it in the next hour. It just, at the end of the hour, it gets compensated at the avoided cost, or excuse me, value of solar. Does that make sense?
Yes, sir. And I appreciate that explanation. Thank you.
So in terms, though, you did ask about the size of systems. Because the percentage of DG that gets generated on site that is exported goes up in an hourly netting condition, and that is only compensated at the small value of solar amount, that payback period will naturally expand, and it expands significantly. We've done studies that indicate in the best case, it doubles the payback period. And this is on our average system, not what Robinson did, but on our average system. It would double the payback period on the best case to 14 years. And in the worst case, I looked at to 70 years.
Okay.
And that depends upon the time of use assumptions you make. Once again, I don't have hourly data, so I can't analyze in excruciating detail and give an accurate result. I can only give a range.
And when you say the average system that y'all worked with, was that the 124 kilowatt?
It was 90.
90.
In DESC territory, it's 90.
Okay. All right.
124 is total state, I believe.
Okay. Thank you. You've stated in your direct that the C&I customers invest in distributed generation to offset their energy usage. How much do your customers, what's their primary, to offset their usage or to offset and export? I reckon I'm talking about sizing of the system here. Are they intentionally sizing systems to export, or really just trying to cover their own usage?
So, yeah, that is a very important point. A solar system will generate, on average, 5 hours out of a day at full power. But in the summer it's longer, in the winter it's shorter. a customer would like to offset up to 100% of their total energy usage. So that means that if you're only generating for, let's say, 5 hours out of the day, you obviously have to overproduce what you might need in that period. And with the current program, you get to bank that and use it at night when the system's not operating. But on average, you can never produce more than you would use on an annual basis in terms of energy, volumetric energy that you use on an annual basis.
And let's just be clear, when you say bank that and use it at night, that's pulling energy that is produced by, in this case, Dominion's generation systems, right?
Right. That energy would be pushed back out on the grid. The credits for would be generated. These are just, virtual energy credits. And then they would net out those energy credits at a later time. But effectively, you can think of it as pushing the energy out during the day and consuming it at night, the energy you produced during the day.
Okay. I think that's all I have, Mr. Zimmerman. I appreciate your clarifications for me. Thank you.
Absolutely. Anytime.
That's all I have, Mr. Chairman.
Thank you, Vice Chair Belzer. Other commissioner questions? Commissioner Caston.
Good afternoon, Mr. Zimmerman.
Hello. There you are.
Thank you for your testimony and taking time. To follow up on Vice Chair Belzer's last question. So if I understood what you were saying, I guess importance or the need for whether it's rooftop solar, residential or commercial or whatever, to have more capacity than needed is so during the time that you can produce energy, you push it out to the electric utility to bank it. So when you can't use your rooftop solar in the evenings, you draw from the utility. Is that what I understood you to say?
Yeah, that's in general the majority of our customers who are looking to do 100% offset. They have to overproduce during the day and then consume that overproduction at night.
How does DESC or any other electric utility, for that matter, how do they store or save that energy?
So that energy is not stored, right? They have to generate on a system-wide basis the same amount as the load at any given point in time. So what happens is the business that overproduces will push that power out on the grid, and the next door, the electrons will basically go to the next business down the road and will be consumed by them, which means, of course, that the grid, the generation that's on the grid by the utility has to be lower by the amount that I export. So, for instance, if I export 10 kilowatts out of my building and it goes to the nearest neighbor, then the grid needs to produce 10 kilowatts less.
Okay, I understand. I guess thinking from the utility perspective, since I can't store the energy, I'm still using my infrastructure, my transmission lines, my generation equipment to produce real-time energy 24 hours a day, 365 days a year. Correct?
Yes.
So I think, as was discussed yesterday, that the most effective and efficient way typically to operate pretty much any utility is to manage the peaking. And by that, not only shorten the time frame if possible, but the level, the height, the peak try to flatten that. So what I'm hearing is that the pushing it back is simply pushing that issue back to the electric utility to deal with rather than the generator. Is that correct?
Not really.
Now, why is that?
The peaking occurs by whatever the loads on the system are, right? If we're exporting power back onto the grid because our generator is overproducing at any point in time, that is just reducing the load on the transmission system going to the nearest neighbor. So it's not increasing in any way the requirement for increased line size or any other capacity inducements here. It's the load is the load, and we're adding more generation just at the edge. So in terms of the peakiness, it doesn't increase the peak, I guess is my point.
I'm not real sure I agree with that or follow that, because I'm thinking in terms of, okay, regardless of what's going through that line, whether it's electricity, whether it's water, whether it's sewer, in that if I, as let's say a water utility, if I have to guarantee every customer on my system that when they turn on the tap, water's going to come out all the time, then that means when everybody wants to use it, which typically, it at least say on an average day, and I've mentioned this before, I think, say just a typical day, when people wake up in the morning, that tends to be when, you take your shower, you put your coffee on, you cook your breakfast, you turn up the heat, you do whatever, and then you go to work, and then when you come home, typically do the same thing. So from my perspective is that I've got to make sure that that's there. So what I'm hearing, if I'm understanding it correctly, is the argument I think you're making is that we want the rooftop customer to be able to oversize the unit to push more electricity to the grid so they can bank that and cover the times when they can't use it, and that has no effect on the utility. And I got to be honest with you, I think it does have an effect on the utility. And because you're basically asking the utility to handle real peaks, real issues. Now, if solar choice is a choice, then why wouldn't it make sense if the goal is to save money, and if I did it, I'd want to do it to save money. If I had it, that you size it to meet your needs. Don't sell it back to the utility, and just use the utility when you need to use the utility at their normal rate. I'm struggling to understand why that's not a choice that would allow any solar user to come out pretty well. What am I missing?
The challenge, okay, so there's a couple aspects to what you were speaking of that maybe I can help clear a little bit. If you design your system for no solar being present, it is sufficiently sized to handle solar being added. What I mean by that is adding additional generation on the grid does not increase the demand. So take, for instance, you've sized the lines coming into this building to handle 200 amps. If I have a 100 amp solar generator, that doesn't mean I need a 300 amp line, because if I export all 100 amps, it's going to reduce the flow coming in the other direction by 100 amps, and the net heating on the line is only 100 amps worth of heating. So they kind of counteract each other, right? So you never have to oversize that system. And if you design your grid for the no solar condition, you're going to have a sufficiently sized grid. The solar is just an additional generator that helps to reduce the amount of generation that the utility has to provide. In terms of system sizing, the legislation, I believe, says that a customer can provide, or the purpose of solar is to offset up to 100% of your energy usage. Energy being measured in kilowatt hours, right? So 100% of my energy usage, if I have 1,000 kilowatt hours per day or per month that I use, I should be able to offset that using solar. To do that, because of the nature that solar doesn't generate 24/7, we'd have to overproduce during the day, bank it, and then take those credits back at night. And that's the way we can achieve that 100% energy offset.
I understand that. If that's the way you interpret it, I honestly can't tell you that's the way I would interpret that. But I guess that's why we're here. That's why we're doing these things. So if I understood you correctly in your testimony, and I think in statements, that you believe, or you want a one-to-one payback from them no matter what. In other words, maintain the status quo. Is that correct? Am I understanding that?
That is the only way that I see that the first two intents of Act 62 can be met. The desire to, continue enabling market-driven private investment and to avoid disruption of the growing market. Right now, if you look at Witness Robinson's testimony, he had indicated in the small commercial about 2 megawatts increase over the next 10 years. That's a 200 kilowatt system every year for the entire Dominion service territory. That is not a vibrant market. And so the only way that I know that we can even come close to meeting the first two intents would be to maintain the existing Act 236 structure.
Well, I believe that is definitely your view. And on I think page 4 of 17 of your testimony, you reference 40-20, actually 5840-20F, and then 5840-20G2, but that's a different story there. I think successor solar, which we still need to clarify, but you do say the commission should consider, and you got a little a, little b, little c, continuing private investment in on-site DG, reducing regulatory and administrative burdens on the deployment of DG, and avoiding disruption of customer scale DG. Is that correct?
Yes.
Well, as I look at those sections, as I literally go back to the law, to Act 62, now whether that's in G or whether it's under F or whether we go back to A, you kind of cherry pick the things you put there, because if you look at everything the law says, it talks about fairly allocating cost and benefits, eliminating any cost shift and subsidization associated with net metering to the greatest extent practical, and things such as that. So I guess I would wonder if Act 236 is all we needed and that's what we ought to observe, why did the General Assembly pass Act 62?
Well, I'm not aware that the General Assembly had any information on market forecasts for the solar industry, and they did clearly state that they wanted to avoid disruption and they wanted to continue enabling that. But I agree that they also say they want to fairly allocate the cost to the greatest extent practicable. But in G1, they also put a phrase in there, while also ensuring access to customer generator options. And I guess my concern is that if the statute goes through as written, or I'm sorry, the tariff goes through as written, knowing what I know about the payback profile, the customers won't have access because there'll be no solar companies left to deliver it.
Well,
and that's my concern. I'm concerned for the customers that want to add solar.
I understand.
And that's why.
Excuse me, go ahead and continue. I apologize.
No, I mean, I just wanted to indicate that the reason I'm here and putting, a substantial effort into, presenting the case of the solar installer is that our customers won't have options if there's no viable market. Nevada is a fine example. And that's why we're here. My business will survive, as I previously, testified. That's not the issue. The issue is being able to have a vibrant solar industry and giving people options.
I understand. I guess something I've learned in the last few days in these hearings is there's certainly, debate on what 584020 says or how we interpret it. I've also learned that there's about 650,000 customers that do not have rooftop solar that I still feel like we need to think about in this equation, because I must be honest, I mean, when I read the law here, I don't know why the legislators would have included fairly allocating cost and benefits and eliminating any cost shift of subsidization associated with net metering to the greatest extent practical if they wanted us to ignore it. If 1-to-1, if the electric utility is required to buy it back at their retail rate and the rest of the customers subsidize that, that's what we should have said. That's what should have been said in the law. We should have just kept it the way it is and said we're going to mandate that that's the way it is. But I don't believe that's what that says. I'm not sure it does. You know, perhaps further conversations will clarify that some, but I understand. You know, you're looking after your customers, your business, and the one-to-one you feel like you would like for that to continue.
Well, we would like that to continue. But to your point, we also do have a settlement proposal with Duke that is not one-to-one net metering, but that was arrived at through discussion and conversation and understanding each other's needs, which has not happened here. That could have happened if, you know, the other parties had wanted to sit down at the table and discuss it. So, you know, my only point here is to say, in my corner of the world, the market we work in, our customers, what has been proposed, and without, you know, anything to the contrary, what would have been implemented would have eliminated their access. The other thing I do want to highlight here, if I can, is I believe it was Mr. Rooks indicated that the cost shift for non-residential total that's on the non-solar customer is $332,000 or 28 cents per bill on a commercial user who might have $1,000 a month bill. I wouldn't consider that an enormous burden on them. Now, other people can make that decision. But we're not talking about enormous sums of money here. And that's with the existing NEM policy. And I believe capturing the incentives that were in place and no longer are in place. So going forward, that number should be lower.
Well, look, I really don't know what it is. I've heard all kind of different numbers. I've heard $1.75. I've heard capped at $1. I've heard that. So legitimate point, and I think something that needs to be better defined. And I will say this, and I think on lines 15 and 17 of page 1 of your direct, I think you were alluding to what you had said about sitting at the table. The commission should find that DESC's refusal to seek industry or customer comment on the proposed tariff is DSC's acknowledgement that the utility seeks to overhaul DG in its service territory and in net metering. Now, yeah, I don't know about that, but one thing, you know, I do agree. I think probably the prudent route to have taken would have been to call the broad range of stakeholders together and try to work through these things before they get to this point. I just think there's wisdom to that. However, that I'm aware of, there's nothing in the statute that requires them to do that. Would you agree with that?
I don't know what's in the statute with regards to stakeholder engagement.
Well, I don't think it does. I haven't seen it. But that said, I do agree that I think that would be probably a preferable, wise and prudent way to do these kind of things. That said, I think that's all the questions I have, and I appreciate it, Mr. Zimmerman. Thank you very much.
Well, thank you. Appreciate the opportunity.
Commissioner questions.
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman, and thank you, Mr. Zimmerman. And it's just a couple of things. I think Commissioner Caston brought up that there has been a lot of back and forth about Act 62 and what is the real mandate. And let me ask you, and I've tried to ask other parties, what do you think the real mandate is of Act 62?
I think first and foremost was to promote additional solar adoption. And then I think some guardrails were put in place to make sure that there's not an overly burdensome cost shift applied to non-solar participants. My personal view is that it should not be overly emphasized, that the cost shift should not be overly emphasized, and that the continuation of solar is kind of the primary mandate 24/7, and we've seen some of their load profiles. They're very consistent. So from a time of use perspective, you know, the load, we can't do much with the load. What I was more concerned about was the netting period, or the period in which export will be allowed to accrue, the credits allowed to accrue before they were cast out at the value of solar rate. Currently, it's a 1-year accrual, and the proposal is to go to a 1-hour accrual. So, it's almost instantaneous. Anything exported is valued at the value of solar rate, not available for use at other times.
So you think the annual netting is a good thing? Leave it alone as it is.
Yes, I do. Okay. I mean, you probably are aware we had a settlement discussion with Duke Energy, and in that we compromised to a monthly netting period. But that was the point of compromise.
Chairman Williams, Taylor speaking on behalf of Alder Energy. I would just caution the witness to discuss not admissible information relative to communications with Duke Energy relative to the stipulation that's been filed.
This is your witness, right?
That's correct.
Okay. Yeah.
I certainly wouldn't want him to interfere with inadmissible evidence relative to that stipulation.
Oh, I don't disagree.
Necessarily, I apologize. I wasn't asking for anything confidential.
And I wasn't intending to share anything confidential. So.
Okay. There's one other thing. The attached to your testimony is a non-residential program application, and looking at the 5 choices, what is the choice that you suggest industries pick from this application?
Yes. So these are the current program choice options available, and since obviously solar choice is not available, it would be net energy metering 3.0 would be one.
Okay. And one last question, and I believe it's kind of come up in your conversation with Commissioner Caston, but I had written down my last question was, besides having our commission just say no, what compromises would you be happy with? What would you have us do? I'd just like to know what your position is. What would you have us do?
I had in my introductory or my summary testimony earlier today, I had indicated 5 things. The first is to balance access to versus cost shifting, right? The second is to allow full retail compensation without subscription fees. The subscription fees are a serious impediment to viability of the project, of solar project going forward. I'd like you to maintain the annual netting. and make sure that 8768 is available for any potential time of use tariff might be implemented. If you stay with the annual netting and don't go to time of use, that somewhat can work itself out at its own time. And then the associated RECs or renewable energy credits should be fully retained by the customer for one generation.
But
those are the 5 items.
You're open to compromise, you're open to settlement, you're open to talking, which hadn't occurred in this case.
Yeah, sure.
Yeah. Thank you, sir. That's all I have.
Thank you.
Any other commissioner questions?
Chairman Williams?
Commissioner Williams.
Thank you. Hello, Mr. Zimmerman.
How are you, Ms. Williams?
Great. How are you?
Good, thank you.
You, in talking with Mr. Spear, you indicated some analysis that you've done with installations that your company has done, and that the average payback was 5.5 years, and the upper limit, I think, was 8 years that you've installed. Is that correct?
That is correct.
Is that something that you can provide to us?
We have provided under discovery all of the proposals to Dominion that encompass that data. What form are you looking for?
I need to learn about that discovery element. I've been picking up on it in this particular case. So if that's something I have access to, I'll find it that way.
And I'm not very clear. Hopefully my attorney can help me with that.
Yeah, Chairman Williams, Taylor Spear on behalf of Alder Energy.
Yes, sir.
If it would please Commissioner Williams, something that we may be able to do is provide a demonstrative aid that expresses some information that's contained in those proposals. The problem that I would have at this point is that those were marked confidential because they contain client information that we certainly wouldn't want to make public record. But I think that there's certainly a way to appease the commission here and as well as protect private and confidential information.
I'm certainly not asking for client names. It's more to kind of understand the analysis and perhaps compare it with other analyses that we're seeing.
Right. And I will add one bit of clarity to that information. There was, of those 40 customers, there was one customer which was a governmental agency. It was a firehouse. Mm-hmm. And their payback period was longer because they could not use the tax credits. So I tend not to consider them. I consider them an outlier in the statistic.
Well, I would like to request the material as Attorney Spear has identified where it's confidential in terms of who the clients are, but understanding that this is these are 40 businesses that we can sort of understand better their payback scenario.
Certainly. Happy to provide that.
Thank you very much.
Surely.
I think it's 11. 10. So, Commissioner Williams, if I understand you correctly, you would like a late filed exhibit with information requested. And I would ask that Attorney Spear file that under seal. And we will reserve an exhibit number for the late file exhibit. It will be entered into the record as hearing exhibit 10.
Chairman Williams, Taylor Spear on behalf of Alder Energy. That is understood. Thank you.
No problem. Commissioner Williams, do you have any further questions?
I do not. Thank you very much.
Thank you, ma'am. Any more questions from commissioners?
Mr. Chairman.
Commissioner Thomas.
Thank you. First off, let me just say that I have some construction going on here at my house today, and occasionally noise starts happening. So if things get too loud and people can't hear me, I'm sure you'll let me know. But first off, let me just say, Mr. Zimmerman, appreciate you being here today and updating us from your perspective as a C&I solar developer. And a couple of things have been said that I kind of want to follow up on. Mr. Knapp asked you about marketing, and you mentioned, I believe, the importance of accurate information in marketing. And I think you also said that you pretty much are kind of a word of mouth or sort of a marketing. Is there any other kind of marketing activities or promotion that your business is involved in?
Well, yes, certainly. We have a number of sales staff that do go out and contact individuals that might be interested. We do a lot with online, Google AdWords, that type of thing. Of course, our web presence, our website is a marketing tool. Sometimes we'll do direct mailings, but that's, that kind of thing, kind of a standard marketing technique.
Okay. And Mr. Culley mentioned some of the press that was related to Act 62. And Mr. Burgess asked you about your actions in order to protect your business interests. And so I guess my question is do you or have you participated in any sort of, let's say, public relations type or lobbying type activities for the purpose of impacting legislation or the regulatory environment?
Not directly. We have been members in the past of the Solar Business Alliance, which has hired lobbyists. The South Carolina Solar Business Alliance. We are members of SIA. We are or have been members of E4, but I don't believe they do lobbying. But never directly.
Okay. Not directly, but perhaps indirectly. And how about a little bit more specifically related to this proceeding? Are you your business, or are you aware of others that might be undertaking activities related to this proceeding?
I am aware that there are other initiatives going on. There are some mail-in campaigns that are out there. People on my staff have signed letters. In terms of any other campaigns, not that I'm aware of.
Okay. Well, I mean, one of the reasons that I'm asking this is in the interest of accurate information. We're in the middle of this thing, so we're going to be shot at from both sides, no matter what we do. And we are going to be having a public hearing in March. And I'm just thinking back to the last public hearing that we had, and we heard a lot from customers. And basically, they believe that they received inaccurate information in connection with some $1,000 refund. They weren't very happy about that. So in thinking ahead to this public hearing, I'm just trying to make sure that I'm aware of whatever sort of information that's being put out there. And hopefully it's accurate information, but that's my concern. Any comments on that?
Well, I will say from our perspective, the only information that we put out is that on June 1, Act 236 net metering will no longer be available to new customers. And I don't believe that that's incorrect. Of course, this is all dependent on what the committee or the commission chooses to do. But that is the only information that we are putting out there.
Okay, thank you. I appreciate that. That's all I have.
Certainly.
Any more questions for this witness by commissioners? Mr. Zimmerman?
Yes, sir.
I have a couple of questions for you.
Absolutely.
Just to lay a bit of a foundation. During the company's case, and I'm sure you were listening in, cost shift was talked about a lot. Eliminating any cost shift or subsidization associated with net metering. It was talked about over and over and over and over and over and over again. I haven't heard it talked about as much today. And I just want to know from you, as a proponent of solar development, how should this commission address the cost shift? That's the general question, but I guess more specifically, do you think that there actually is a cost shift? Some believe that solar is undervalued, but I'm just curious about your thoughts on this concept of a cost shift, and if you believe one exists, how should that be resolved?
That's a very good question. As a business person, I'm always weighing the costs of one thing versus another. And I believe that the fundamental question is the ones that you have been asking are, how much is each non-participating customer impacted? And in that case, what exactly should we do about it? There's another docket, the value of solar docket, that also has a number of questions in it in my mind, where the environmental value is not really considered, the societal value is not really considered. That if you started putting in what I would consider reasonable numbers in those places, the value of solar would increase. As the value of solar increases, the amount of cost shift decreases due to that banking. And so you ask the question, do I believe that there is a cost shift? I can't tell you whether it's yes or no, but I believe it's overstated. But it, once again, does depend upon how you value exported solar energy. So I think that to me, that's really the way to look at that. I mean, that is a very difficult question to answer, and I wish I had a really solid prescription for you, but I don't.
I understand, and I appreciate your answer. I don't know how difficult it is to determine whether or not there's a cost shift if there are customers that are not using solar that are paying any level of cost for customers that are using solar. I can see why that would be described as a cost shift. Now, whether or not it's overstated is to be determined. I wonder, do you have any equation or any mathematical formula or any insight you can offer us to calculate the cost shift? I know the company's witnesses presented a lot of mathematical information regarding how to calculate the cost shift and what that cost shift actually is.
Yeah, sir, unfortunately, I'm not a rate expert, I would consider myself a solar customer expert, an industry expert, but I wouldn't necessarily say I'm a rate expert.
Understood. That's fair. I think I heard you testify that there was some level of fanfare regarding Act 62 and how it may or may not, I guess you should say, expand solar opportunities and promote the solar market, so forth and so on. But when you look at 58-40-20, I mean, it's unavoidable to notice that there's an issue with the cost shift. And so if I were in your business, I would be greatly concerned, especially considering that this cost shift is one of the incentives to deploy solar. The incentive that one-to-one, the banking, it's a pretty big incentive to deploy solar, but that cost has to be borne by someone. And if I were looking at this, I would be greatly concerned that someone is looking to reduce those incentives, or reduce the cost shift, which would mean the incentives have to be reduced. Did you not have that level of concern when you read 58-40-20?
Absolutely. I mean, I absolutely have that concern, and that's why I'm here. I would not have endeavored to commit this amount of time and money to being in front of you right now if we weren't fighting, for the solar customer and fighting for, a viable market going forward.
Right. So, and to me, hearing that answer leads me to believe that you acknowledge that there is a cost shift, and you acknowledge that the General Assembly was concerned enough about the cost shift to ask the Commission to consider it, and not only consider it, but to make sure that costs were allocated fairly, and to eliminate any cost shift or subsidization associated with net metering to the greatest extent practicable.
Absolutely, yeah. No, I completely. I've never said that doesn't exist and it isn't a consideration or a concern. I guess I'm just saying that I don't believe it's the only concern and the only consideration.
Understood. So, and you may not be able to answer this question, but how much of a haircut can your industry take? As proposed, I believe the companies, and I didn't mean to cut you off, but I just want to help you answer the question. As proposed, I think it's my understanding that Dominion's solar choice tariff reduces the cost shift by approximately 75%. I don't know if you heard that yesterday or the day before.
I didn't get the percentage. I had heard them indicate that it wasn't perfect. It didn't get to 100%, but I didn't know where it got. So 75%. Okay.
Is 50% practicable? 25%?
Well, I think whatever. I would certainly like it to be gradual, and I don't know if I can put it in terms of percentage. What I can say is this, Mr. Robinson from Dominion had indicated a very feeble solar growth with the old tariff. I would find it very hard to believe with the new tariff it would be any better. I think it will be certainly worse. My calculations indicate that that it would be markedly worse, that most paybacks would go outside the realm of interest to most customers. But to answer your question, you know, what would be tolerable. You know, I think that I mean, I don't want to just pick a number out of thin air, I guess. You know, that would be a very inappropriate thing to do.
And I won't ask you to do that. I won't ask you to do that. I don't want you to think if you had an answer, that would be fine. I would love to hear it, but I don't want you to think I'm expecting you to give me a percentage right now as you sit there in your office. I guess the point I'm really trying to make, or I guess ask, is that you acknowledge that there needs to be a reduction in the cost shift. You don't believe, do you, that customers? I'm sorry, sir.
Okay, I believe that is one of the considerations, absolutely, and there should be some reduction in cost shifts, and I believe that is what the General Assembly asked for.
Okay. So if you believe that, you don't think that the commission is killing solar development or depressing solar development by addressing the cost shift in some way, shape, or form, do you?
No, I don't believe that the commission is intending to kill solar. I think it could be a potential unintended consequence of having a drastic change in the calculation cost shift.
Right. Well, so let's talk about you're a businessman. I heard you list out all of your degrees and accolades and certifications. So I know the words market driven make sense to you. Would it not be fair to say that enabling market driven growth doesn't necessarily mean that the growth needs to be expansive or on a large scale? It just means that whatever the market can bear. In fact, could it not be argued that market-driven growth could be interpreted to mean solar should only be able to be deployed at the level customers are willing to pay the actual price to deploy solar, or as close to that price, the actual cost, the real cost, if you will? Even if, and I know I'm asking a lot of questions at once, but even if we want to get the market driven, even if the number of customers, new solar customers, decreases due to implementation of a solar tariff that seeks to reduce cost shift, wouldn't that be more of a market-driven approach?
When I think about the language market, continue enabling market-driven private investment, to me, what that means is, when I think of market, I think the market is people who are interested in putting solar onto their business, or in the residential sense, onto their home. That's the market. Market-driven is correct. There will be some people who can afford it, some people who can't. But if you have like my analysis had shown, if you have a payback period that's outside the useful life of a system, it will never be economic value generated from that system. And some of the, I took our average system, modeled it, and with some parameters that were, yes, variable, we were able to get at least half of these runs that were outside the useful life of the system. And in no case were we able to do a run that didn't double the payback period with the existing tariff, with the proposed solar choice tariff, excuse me. So the point I'm getting at is You asked a question about market driven. I realize that. What does that mean? I believe that is subject to interpretation. But I do believe when I think about addressable market, it is all those people that would like to go solar and have the financial means to go solar. That's the addressable market. And they shouldn't be impeded from doing that.
So what is the impediment under the solar choice tariff proposed by Dominion?
The impediment is the financial return. If it's not within an acceptable range that people are willing to accept, I'll take in the case of businesses. Business is typically looking for a 4 to 5 year payback on other investment alternatives. If you have a payback which is significantly greater than that, it is not a viable project.
Would you not agree that that incentive was artificially created by cost shifts and subsidies?
I believe that was what the intent of the original Act 236 legislation was. And that was the letter of the law. And at that point in time,
I'm sorry, sir, go ahead.
I mean, at that point in time, Act 236 time, that was what was acceptable to the legislature.
And could it not be with Act 62 that the General Assembly is seeking to correct the market, even if that means solar development will not be as expansive as it was under Act 236?
That could be. I just look at the words here and I try and understand them as well as you do.
Sir, you and me both. Let me ask you this. Can you tell me or identify any regulatory or administrative burdens to customers that exist with the installation or utilization of on-site distributed energy, particularly solar? Are there any administrative or regulatory burdens that exist?
Oh, there are, sure. They tend to be wrapped around obtaining interconnection agreements, administrative burdens, typically involved, but they're at generally at the zoning, planning, and permitting boards. Not anything that's necessarily in your purview except for the interconnection dockets.
Okay. All right, sir. Those are all the questions I have for you. Commissioner Caston has a few more questions for you.
I'm sorry, I wanted to follow up actually on kind of build on what Chairman Williams had said as I wrap my head around all this and try to kind of sum it up. At least my understanding, what I think I've heard through the course of the last few days, including your testimony, Mr. Zimmerman. As I recall, and I think Docket 2019-184-E, which has been referenced, I think, a time or two, established this commission. Of course, I wasn't here then, but the Public Service Commission established the avoided cost. And I don't recall what that was, but it was about 4.5 cents, as I recall. Maybe Mr. Rook or someone had mentioned that in testimony. I don't recall. And because of the one-to-one NIM, the utility has to buy it back at retail rate, which is a little over 11.6 cents per kilowatt hour. So that's a net difference of, I guess, a little over 7 cents. And it appears to be that the solar choice tariff, whether the numbers are right or not, or whether this fee's right or not, at this point in time, I don't know. But it's still a choice, as I understand it. If you don't want to use it, you don't have to use it. So if you have rooftop solar and want to save money for your household, you simply use your photovoltaic devices to produce electricity and use for your consumption and your whatever you do at home. And then when you can't do that, or if you don't have battery storage, you simply use the utilities electricity on demand. And if you use whatever rate structure they have that doesn't sell it back to them at retail, then you have the reduction. Well, first, you eliminate all those fees that they're proposing in solar choice, whether they're good or bad, it eliminates them. You have a lesser base charge. I think it's $9, I think. And then you don't pay them for electricity when you're generating it. So as I've started understanding that, it's like, well, you do have a choice, and that sounds like a pretty good choice. But I think I've also understood that the whomever, whether it's the user or the solar developer or manufacturer, thinks it's more beneficial for the customer to have larger systems so they can generate more electricity and sell it back to the grid at 11.6 cents per kilowatt hour and make money, which I guess is called banking. So at night, it's kind of like you're drawing from that bucket and, it works. I'm beginning to see that, I'm not sure that is I think banking can be a tad misleading. It's like we're storing it somewhere and you can use it and it doesn't cost any more. So I guess what I'm starting to understand is that this commission set the avoided cost rate. The commission did it. Duke didn't. Dominion didn't. We set it. And whether we all agree with how they're doing it, their method, even if the numbers are right, I can't say. I'm not in a position to say right now. There is a cost difference of about 7-point-something cent that somebody's having to pay for, and as I understand it, about 650,000 other people. So I appreciate that this. Hey, look, I get it. If you can produce your own electricity and then sell it back at a retail rate and then benefit from that, yeah, that's definitely a plus. But I really believe that is why that verbiage is in Act 62, because it was recognized some time back. And building on what Chairman Williams said, I'd be a little surprised or shocked if we all showed up at this hearing and just now discovered this. Because as this legislation was being developed, I'm sure that verbiage was proposed, and if people are keeping up with it, I wasn't, but if people were keeping up with it, they knew that, hey, that language is being proposed, and it's in there for a reason. So, again, I'm not saying I know what the right answer is, but that language is in that legislation for a reason. And we passed, by a separate docket, approved an avoided cost. And that paragraph F is in there for a reason too. So along the lines of what Chairman Williams said, I'm not saying what the answer is, but we probably, as a whole, need to kind of rethink some of this. Anyway, that didn't ask you a question at all, but what do you think about what I just said, Mr. Zimmerman? Does that make sense to you? Have I summarized this accurately?
I believe you have summarized a very good portion of it accurately. I think as I read what the legislation that the General Assembly has put forth, I do look at the intents of the language very closely, and I do identify that number 1 and number 2 are about continuing the solar industry. And number 3 is about the cost sharing. And the way I read it, to the greatest extent practicable, to me, if I were sitting on the commission, which is not the question you asked, but I'll say it anyway, I would look at the extent of how to gauge what the greatest extent practicable is I would say, well, we want to reduce the cost shift as low as we can and still maintain a solar industry. And that's how I would interpret, the mandate, the charge. And going further to Section G of that in that area, it talks about eliminating the cost shift while also ensuring access to customer generation. To generator options, excuse me. That to me also says, don't kill the industry to lower the costs. So that's the way I interpret what you're saying. There are a number of things I've seen done in other jurisdictions that could solve this problem. That's not the question you asked.
I understand, and thank you. I'm sorry, were you through? I apologize.
I am, yes.
And I think something Vice Chair Belcher brought up yesterday in the reference to that Section G is that's something hopefully the attorneys will be looking at in closing statements and arguments, because I think that references successor solar choice, and that's what does successor mean? And in any event, thank you, Mr. Zimmerman, and thank you, Chair Williams.
Thank you.
Any more questions from commissioners for this witness? Redirect.
Chairman Williams, Taylor Spear, on behalf of Alder Energy Systems, no to redirect. Thank you.
We're in recess until 2:35. Good afternoon, ladies and gentlemen. Thank you for joining us for the Public Service Commission of South Carolina's hearing in docket number 2020-229-E, Dominion Energy South Carolina Incorporated, establishment of a solar choice metering tariff pursuant to South Carolina Code annotated section 58-40-20. Before we call roll, it has come to my attention that I need to put something on the record. Earlier this morning, the applicant made a motion to have the commissioner from District 4, Commissioner Irvin, recuse himself due to the shocking nature of the motion. We went into recess. Once in recess, I received notification from Commissioner Irvin that he had decided to recuse himself, and I called him to confirm that's what he wanted to do. He said that is what he indeed wanted to do, and he did so once we went back onto the record. I just wanted to make sure no one was confused about what happened. There was no commission action on the matter. Commissioner Irvin volunteered to recuse himself as was requested by the applicant. All right, let's take roll. In the hearing room, we have Commissioner Caston, Vice Chair Belzer, Chairman Williams. Joining us virtually, we have Commissioner Powers, Commissioner Williams, and Commissioner Thomas. All right. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever. Are you ready to proceed?
This is Kate Mixon for CCL and Upstate Forever. Because we had a joint witness along with Vote Solar, SIA, and NCSEA, we had proposed to present witness Tom Beach first, followed by witnesses Eddie Moore and NCSA and SIA, Justin Barnes. If that is the commission.
Sure. Yeah, go right ahead. That's what I was expecting.
Wonderful. And that colleague will be presenting Mr. Beach. Thank you.
Okay, thank you, Ms. Mixon, and thank you, Chair Williams. So on behalf of Vote Solar, South Carolina Coastal Conservation League, Upstate Forever, Southern Alliance for Clean Energy, Solar Energy Industries Association, and North Carolina Sustainable Energy Association, I would like to call R. Thomas Beach to the stand.
Mr. Beach, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you so much.
Good afternoon, Mr. Beach. Would you state your full name for the record?
Yes, my name is Rodney Thomas Beach, B-E-A-C-H.
And by whom are you employed and in what capacity?
I'm a principal consultant at Cross Border Energy.
Did you prepare or cause to be prepared 32 pages of direct testimony that were pre-filed with the Commission on January 22nd, 2021 in this proceeding?
Yes, I did.
And if I asked you the same questions today that are in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Well, Mr. Chairman, I would ask that Mr. Beach's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Beach's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chair. And Mr. Beach, did you also prepare or cause to be prepared 2 exhibits that were attached to your pre-filed direct testimony?
Yes.
And do you have any changes to those exhibits at this time?
No, I do not.
Mr. Chairman, I'd ask that Mr. Beach's pre-filed exhibits be entered into the record as the next composite hearing exhibit.
Mr. Beach's exhibits will be entered as a composite exhibit and entered into the record as hearing exhibit 11.
Thank you. And Mr. Beach, have you prepared a summary of your direct pre-file testimony?
Yes, I have.
Please share it with the commission at this time.
Commissioners, I appreciate the opportunity to appear before you today. My direct testimony consisted of two parts. First, my proposal for a new residential solar choice tariff for Dominion Energy, South Carolina, consistent with Act 62. And second, a critique of Dominion's proposed solar choice tariff. The key features of the joint clean energy solar choice tariff that I proposed are, first, a requirement that new solar customers take service on the rate 5 time of use rate following deployment of an advanced metering infrastructure and availability of a year of time of use usage data. Second, a minimum bill that recovers the approved customer-related costs that do not vary with usage to the extent that this amount exceeds the basic facilities charge for rate 5. And third, a change to the crediting provisions of the net metering tariff for time of use rates to keep all excess on-peak kilowatt hours that are rolled over to subsequent months as credits only against subsequent on-peak consumption. My testimony shows that this joint solar choice proposal will result in a small decrease in the bill savings available to typical residential customers who install solar when compared to the existing NEM tariff. My cost effectiveness testimony analyzing Dominion's current NEM tariff submitted in my rebuttal testimony in docket number 2019-182E showed that Dominion's current NEM tariff is cost effective today, and thus it's not strictly necessary to make changes to Dominion's net metering tariff to comply with Act 62. Nonetheless, it's important to make progress toward a rate design that can serve as a platform for customers to adopt multiple types of distributed energy resources and that aligns more closely with the utility's time-varying cost of service. I believe that the solar choice tariff that I have proposed will provide that platform. My testimony analyzed the proposed joint solar choice tariff using the full set of standard benefit cost tests that cover the perspectives of the major stakeholders in the deployment of distributed solar. Consistent with Act 62, this analysis considers a comprehensive list of benefits and costs and employs a long-term life cycle assessment. I use the long-run avoided costs for generation, transmission, and distribution that I developed for Dominion in my prior testimony in docket number 2019-182E. The proposed joint solar choice tariff passes all of these cost-effectiveness tests. And based on these cost-effectiveness results, I concluded that the proposed joint solar choice tariff will not cause a cost shift to non-participating residential ratepayers, will benefit all Dominion ratepayers, and in the long run, will reduce Dominion's cost of service. And this includes benefiting low-income customers. The final section of my direct testimony contained a critique of Dominion's proposed solar choice tariff. The utility's proposed tariff includes large, new, fixed monthly fees, including both a high basic facilities charge and a new subscription fee based on system size. The utilities tariff also uses a solar-specific time of use rate and moves to the netting of imports and exports on a 15-minute basis. Dominion's proposed tariff would result in a 55% reduction in the bill savings for a typical residential solar customer who today installs about a 7-kilowatt system. As a result, a typical residential solar system would no longer be economically viable in Dominion service territory. And let me explain that. The typical 7-kilowatt system, which Dominion used to develop its tariff, would have an initial cost of $26,040. After the federal and state tax credits, the capital cost would be $12,910. Given the monthly bill savings that I calculate of just $52 or $624 per year under the Dominion tariff, the simple payback on this system is over 20 years. That's not a reasonable investment. The Dominion Solar Choice Tariff rewards residential customers who use a lot of energy, either because they are wealthier or because they use energy inefficiently. I show that the result of this structure is that the only residential solar systems that would continue to be economic are small systems of 3 kilowatts or less installed by large residential customers for whom the solar system would serve just 40% or less of their usage. Smaller residential customers with lower usage would no longer have an economic opportunity to install solar on their more modest or more efficient homes. In fact, the Dominion tariff would encourage wealthy and or wasteful customers to game the utility solar program by installing just a few panels to allow them to access a Dominion solar choice rate that would provide them with major bill savings from lower energy charges compared to the standard residential rate. This is not the result that Act 62 intended. A key difference between my analysis and Dominion's is that I do not assume that all transmission and distribution costs allocated to residential customers are fixed and should be recovered through a fixed monthly subscription fee, as Dominion did. This assumption is contrary to Dominion's own cost of service study. Residential solar systems will produce significant output to reduce the coincident and non-coincident peak loads that cause Dominion to incur demand-related transmission and distribution costs. And Act 62 requires accounting for those benefits. So that concludes my summary.
Thank you, Mr. Beach. Mr. Beach, the cause to be prepared, 25 pages of surrebuttal testimony.
Yes, I did.
Okay, those were pre-filed with the commission on February 19th, 2021 in this proceeding, right?
Yes.
And if I asked you the same questions that are contained in your pre-filed surrebuttal testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, I would ask that Mr. Beach's pre-filed surrebuttal testimony be entered into the record as if given orally from the stand.
Mr. Beach's pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you. And Mr. Beach, have you prepared a brief summary of your surrebuttal testimony?
Yes, I have.
And please share it with us at this time.
My surrebuttal testimony responded to issues from ORS's direct testimony and from Dominion's rebuttal testimony. The first part of my surrebuttal testimony addressed adjustments that ORS witness Horry proposed to Dominion Solar Choice Tariff. In response to Dominion Solar Choice proposal, ORS has proposed adjustments that would have the effect of closing off any economic opportunity for customers to install even small 3 kilowatts or smaller solar systems. ORS failed to recognize or evaluate any benefits of distributed solar beyond the basic avoided energy and capacity costs that apply to large wholesale qualifying facility generators. Failing to consider any additional benefits was contrary to witness Horry's recommendation in the methodology docket, where he took the position that Dominion's avoided transmission and distribution costs should be evaluated and considered in the development of its solar choice tariffs. Finally, both ORS and Dominion failed to quantify the avoided costs associated with decarbonizing South Carolina's electric system. In sum, ORS and Dominion failed to consider how expanded distributed solar can avoid the need for costly future utility investments, avoided costs that will benefit all ratepayers over time. I note that the solar industry was able to reach a settlement with the Duke utilities on their solar choice tariffs, in significant part because the Duke utilities do recognize significant avoided transmission and distribution benefits from distributed solar. My surrebuttal testimony also responded to various issues in the rebuttal testimony submitted by Dominion. Key points of this response included, first, it's not unreasonable for marginal or avoided costs to exceed embedded costs. Second, there are a number of ways for the Commission to give weight to important societal benefits without including them directly in the calculation of solar choice rates. Third, I support using rate 5 with Dominion's standard time of use periods rather than Dominion's proposed non-standard time of use periods in its solar choice proposal. And finally, I refute Dominion's claim that the joint solar choice tariff that I've proposed would harm low-income ratepayers. So this concludes the summary of my rebuttal testimony.
Thank you, Mr. Beach. Mr. Chairman, Mr. Beach is ready for and available for cross-examination and commission questions.
Thank you. Alder Energy Systems.
Commissioner Williams, Taylor Spear on behalf of Alder Energy Systems. Good afternoon, Mr. Beach. I'm going to be brief with you. Do you recall us having a similarly brief conversation during November last year in which you testified in the generic docket?
I believe we did, yes.
Okay. To cut it short, I'll represent to you that Alder Energy Systems focuses almost exclusively on non-residential customer generation. So if I ask you any question, it's going to be within that framework. I'm not asking you questions relative to residential customer generation in South Carolina. Is that fair? You comfortable with
Yes, I remember your interest.
Okay, thank you. You opine in this case, do you not, that for residential customer generation, the Dominion proposed tariff, and specific with the subscription fee, you opine that that subscription fee is a penalty, do you not?
Yeah, I think I would describe it that way because it doesn't reflect the fact that distributed solar actually can avoid transmission and distribution costs, and it treats distributed solar as not being able to avoid those costs at all by establishing that fixed subscription fee.
And you would agree with me that that subscription fee is it's a fixed fee based on installed capacity, correct?
Yes.
That's correct for residential and non-residential, correct?
That's my understanding, yeah.
And the subscription fee price is even greater for non-residential solar than it is for residential customer generation, correct?
I'll accept that. I haven't looked at the numbers for small commercial recently, but I will accept that.
How about 650 per kW of installed capacity? Does that ring a bell at all?
Yeah, well, that is higher than the residential proposal.
Assuming that's correct, which I would represent to you that it is, but as Mr. Culley says, subject to check, your testimony in that regard would stand. I want to do some simple math with you here. So if it's 650 per kW of installed capacity, and a non-residential solar customer installed a 1 megawatt system, which we understand is permitted by South Carolina law under current NEM policies, would you agree with me then that the monthly fee on a 1 megawatt system under Dominion's proposed solar choice tariff is $6,500 a month?
Yes.
How about that's close to $80,000 a year?
I think that math sounds right.
Okay. Would you have any problem, given that it's a fixed fee, would you have any problem correlating your opinion that the residential subscription fee is a penalty, and also under the same logic, the subscription fee under the non-residential tariff proposed by Dominion is similarly a penalty?
Yes, I mean, commercial distributed solar systems will avoid transmission and distribution costs in the same way that residential systems will.
That's all I have. Thank you so much for your time, Mr. Beach. We appreciate you being here. Commissioner Williams, I turn this witness to you.
Thank you, sir. Frank Knapp, Jr.
Thank you, Mr. Chairman. I appreciate it. And Mr. Beach, welcome. Thank you for your testimony. We appreciate that. Mr. Beach, my name is Frank Knapp. I don't know if you have been listening to the hearing up until now. Have you, sir?
I've been listening to portions of it.
Okay, well, if you missed the portions when I was doing my cross, I am not an attorney. I am representing myself. I do have 2 commercial installations. I do not have a residential, and there's a backstory to that, but I won't go into it. So did you develop an alternative solar choice tariff for small commercial generating customers?
I did not.
Okay. All right. Thank you. Would your criticisms of Dominion's solar choice tariff for residential generators be similar, possibly, to the company's proposals for the small general service generators?
Absolutely. I think the same arguments would apply to small commercial.
Okay. Thank you very much. Appreciate it. Does your joint clean energy solar choice tariff achieve the intent of Act 62?
Yes, I think it does.
And why is that?
Well, I think that it first of all, it provides a more advanced rate design to support solar going forward in South Carolina. In other words, a time of use rate design. It's also based on cost of causation principles because it includes a minimum bill that covers the costs that do not vary with the customer's usage. And I think it cleans up some of the crediting provisions to make them so that on-peak kilowatt hours that are more valuable can be fully credited to the customer. In my analysis, it's a cost-effective tariff so that there's no cost shift. And that is obviously a significant part of Act 62. And so I think it achieves the balance that Act 62 is seeking to both make sure that there's no cost shift to non-participating ratepayers, while at the same time making sure that there's a platform for solar to continue to grow in South Carolina.
Thank you, sir. In regard to the cost shifting, we've heard testimony even from the company's witnesses that the cost shift is 28 cents would be 28 cents a month for a general service and $1.38 a month for a residential. But that cost shift really isn't happening right now, to my understanding, because rates haven't changed, and they would be taken into consideration at a future rate case. So when we talk about cost shift, we're talking about a future event. Was your understanding?
Well, the analysis that should be done for the cost effectiveness of distributed solar should be a long-term analysis that covers the full life cycle of the solar facility. And a lot of the benefits that solar will provide to the utility system, for example, avoiding transmission and distribution capacity costs, avoiding generation capacity costs, those are all going to be recognized over time, over the 25-year lifetime of a solar installation. The energy benefits are recognized immediately because the solar system produces energy that displaces energy that the utility would have to generate in that moment in one of its power plants. But the capacity-related benefits are the kind of thing that will happen over the long run, over time, over multiple rate case cycles. The utility will not have to spend as much on its transmission and distribution system as it would have if the distributed solar didn't exist.
So that is a pretty important benefit to the non-generating classes, is it not?
Absolutely, yes.
It's hard to quantify that possibly, but in your experience, rates are often adjusted upward considerably when there is a requirement for a new generation to be added.
Yes, and but if customers are producing a significant amount of energy on their own premises, then the utility will have to make fewer investments in the future to serve them because customers are at least partially supplying their own energy on their own premises using private capital.
Thank you. And one last item I wanted to chat with you about is because you were actually the first witness that talks about another benefit to the non-generating customer. and that is the benefit of affecting positively our environment, correct?
Yes. Yeah, there is going to be a significant cost to decarbonizing the electricity system. And I think my understanding is Dominion has a significant corporate commitment to doing that. And it uses, if you look at a number of the scenarios in their IRP, they assume a positive carbon cost in a lot of their forward-looking IRP scenarios. And so, obviously customers producing clean energy on their own homes will help the utility to decarbonize its system more quickly, and in the long run save it costs from having to do it itself.
Well, but it's not just helping the company decarbonize and reach their decarbonization goals, if decarbonization is a word. It's also simply a matter of all of us and what we are going to experience from having continuing carbon pollution. We're talking about the impact on our climate. So aside from, Dominion Energy is, to their credit, wanting to cut back on their carbon use and carbon pollution, but they're doing it for a reason, are they not? Are they not doing it to address climate change?
Yeah, absolutely. I think that, and I think that most of the studies have shown that the benefits of doing that exceed even the costs that are the carbon costs that are assumed in Dominion's resource plan, for example. And it's sometimes called the social cost of carbon, and it is based on avoiding damages from climate change that we are seeing increasingly, whether it's in wildfires in California, cold freezes in Texas, or increased hurricanes, in the Atlantic. There's a lot of benefits from making sure our climate doesn't get out of control.
And those costs from those climate change, South Carolina, you mentioned hurricanes. That is a major cost to South Carolinians and an area of taxes. We're talking about extreme heat that impacts people in their homes when they have to turn up their air conditioning, right, to stay cool. That costs them more money. We're talking about sea level rise, which is being driven by climate change, and what the impact is along our coast to property values and to impairing our small business tourism economy. These are all costs that are happening because of carbon pollution and climate change, and mitigating those costs can be looked at as part of this cost shift that's going on. That there is a benefit to those non-generating, and they will benefit from this whole effort to promote solar. Correct?
Yeah, I think that what we've been talking about are what you would consider societal benefits, and I'm not sure. I think that the direct compliance costs for mitigating carbon emissions, for example, that Dominion assumed in its IRP, those costs are appropriate to consider in a cost effectiveness evaluation. The broader societal benefits of reducing damages from climate change probably shouldn't be considered as part of the direct construction of a solar choice tariff. But my rebuttal testimony suggests a number of ways that the commission may want to think about those societal benefits. For one thing, all of these analyses that we've talked about in this case have a certain amount of uncertainty in them. And I think that one of the values of thinking about the societal benefits is that if the societal benefits of doing something like having a successful solar program are significant, then it allows you to have more certainty that the direct benefits that you've calculated are going to materialize, even though you know that some of those direct benefits are based on forecasts that may have certain uncertainties in them. But if there are a lot of societal benefits, I think that offsets the inherent uncertainties in some of the direct benefits, if that makes sense.
Well, thank you, Mr. Beach. And one last thing, I'm going to turn to a personal question then. What does your proposed solar choice tariff compared to the company's offer, how will that impact me as an owner of a commercial installation using today's solar net metering?
Well, I'm not sure that if you are grandfathered under the old net metering program, it may not affect you at all. But if you're going to put a new solar installation on, the proposal that we've made would reduce the bill savings from installing residential solar by on the order of 5 to 10%, whereas Dominion's proposal would reduce it by over 50%, 55% for the typical system. And I think the ORS proposal would be even worse. So, that gives you a sense that the tariff we've proposed would be a moderate step down in the compensation for solar customers, but I think it would still maintain a viable market in South Carolina. Whereas the proposals that the Dominion and ORS have put into this case would really, for example, Dominion's proposal would mean that it would only be economic to install a very small system on your house. And it would just that alone would cut the market in half. Instead of customers installing 7 kilowatt systems, there would only be an economic incentive to install 3 kilowatt systems. And I think that there would be a similar impact in the commercial market as well.
And your proposal, as you said before, would meet the intent of Act 62.
I believe it would, yes.
Mr. Beach, thank you very much. I appreciate your time. And Mr. Chairman, I have no more questions.
All right. Thank you very much, Mr. Knapp. Let's go to Solar Energy Industries Association.
Good afternoon, Mr. Chairman. We have no questions for this witness, and we thank Mr. Beach for his testimony.
All righty. North Carolina Sustainable Energy Association.
I'm going to stay on and also say that NCSEA has no questions for this witness.
All right. Vote Solar.
Sorry, Mr. Chairman. Yeah, we have no. I would obviously have no questions for our witness here, but thank you for signaling us.
Office of Regulatory Staff.
ORS has no questions for this witness. Thank you, Mr. Chairman.
Applicant.
Good afternoon, Mr. Beach. My name is Chad Burgess, and I'm in-house corporate counsel for Dominion Energy. How are you today, sir?
I'm all right. How about yourself?
I'm doing great. Thank you. Just got a few questions for you, Mr. Beach, and I want to start off with a statement that you just made to Mr. Knapp. You stated that the ORS proposal was worse than the Dominion Energy South Carolina solar metering. Did I understand your testimony correct?
It is certainly, it's worse in terms of it would result in a larger reduction in bill savings over the range of possible solar system sizes.
But your testimony is that their recommendations are not good for the solar industry, correct?
Yes.
Okay. And you are you understand, do you not, that ORS represents the public interest in this proceeding, do you not?
I will take your word for that. I don't know exactly what their mandate is.
Do you also take it at my word that they do not represent the financial interest of Dominion Energy South Carolina?
I would suspect that's the case, yes.
And would you also take it at my word that they do not represent the interest of the solar industry?
Yes.
And you would take it at my word, would you not, that their sole focus is on the using and consuming public?
That would make sense to me that's part of their mandate.
Hey, Attorney Burgess, I hate to interrupt you. I'm hearing from my producers that Mr. Knapp needs to mute.
I saw that too, Mr. Chairman. Hopefully. I think he's muted now. Thank you, Mr. Knapp. Okay. So, Mr. Beach, have you read Act 62?
I have, yes.
And when you read Act 62, I presume that you also read the section which addresses the solar choice metering tariff, correct?
Yes.
In fact, in your testimony, you even cite Act 62, do you not?
Yeah, numerous occasions.
That's right. And when you cite it in your testimony, and I'll refer you over to page 10 of your direct testimony. Do you have your direct testimony nearby?
Yes.
Okay. If you'll flip over to page 10, and I'm at line 13, just let me know when you're there.
Okay. I may be looking at a version with different pagination than yours, but if you could, I think I'm close.
Okay, we'll get there together. So the paragraph that I'm looking at begins, the third consideration is to address directly. Do you see that?
Yes. Okay.
Okay, very good. And then on line 12, just right below there, it states, or you have testified, I should say, section 58-40-20G1 of Act 62 provides that the new solar choice tariff should, and then you quote the remaining piece of the statute, eliminate any cost shift to the greatest extent practicable. And you're telling this commission that the statute states that the commission should eliminate any cost shift to the greatest extent practical, correct?
Yes.
But you said earlier that you were familiar with Act 62, so I'm going to share my screen here for 1 second. All right, and can you see my screen, Mr. Beach?
Yes.
All right, so you see section G right there where my cursor's nearby?
I do.
And that states in establishing a successor solar choice metering tariff, the commission is directed to eliminate any cost shift to the greatest extent practical.
I see that.
Okay, very good. And you would agree with me that the General Assembly did not use the word should eliminate any cost shift, did they?
I mean, they used words that are certainly could be interpreted to say that the commission should do this. I mean, I realize that lawyers may distinguish between should and shall and is directed to. I'm not a lawyer. It certainly seemed like using should there is very similar to is directed to.
Okay. So your definition of should means that someone shall do something, correct? Rather than a recommendation.
It's certain, directing the commission to do something is, that's a fairly strong, whether it's a should or a shall. Again, I'll leave that to the attorneys to debate, but it certainly is maybe we should say an affirmative direction.
So you would agree with me that this commission has a obligation under the law to eliminate the cost shift, correct?
I certainly would agree that in establishing a solar choice tariff, the commission needs to look at if there is a cost shift, and it doesn't direct them to completely eliminate it. It says to the extent practical, because there are other considerations in Act 62 that may conflict with eliminating the cost shift. For example, having a viable solar market in South Carolina. So the statute includes some provisions that are going to require the commission perhaps to do a balancing act, and that are some of the provisions of Act 62 are will to some extent conflict with each other or require the commission to achieve a balance of interests.
And I know you're not a lawyer, Mr. Beach. You said that in Act 62, the commission should maintain a viable solar industry. I missed that part of the act. Could you point me to where you're relying upon that statement?
Mr. Chairman, this is Thad Kelly with Vote Solar. I would just ask Mr. Burgess if Mr. Beach needs him to scroll up or down as needed to find what he's looking for.
Mr. Beach, do you need me to find that word for you?
I am trying to find where I've discussed that section of Act 62.
Okay. Well, we can move on, Mr. Beach, and I would represent to you that language is not in Act 62. Mr. Beach, are you familiar with DESC's existing net metering tariffs?
Yes.
And isn't it true, Mr. Beach, that there is a cost shift built into the current net energy metering tariffs today?
No, I don't think there is.
It's your testimony, Mr. Beach, that there is no cost shift that exists in the current net energy metering tariffs as they exist today?
Based on the evaluation that I did in the methodology docket, that's correct. I don't believe that there is a cost shift today. If you have to look at more than just avoided energy and generation capacity benefits. If you look at a broader set of benefits as I believe Act 62 requires, then you'll conclude that there is no cost shift.
Okay. And Mr. Beach, so it's your testimony that the current net energy metering tariffs are in compliance with Act 62. Is that correct? Is that your testimony?
Yeah, I think they could be regarded as in compliance in terms of a cost shift. Now, whether you want the current net metering program to be the platform going forward is another question. And when I looked at that, I decided that the best platform for all kinds of distributed energy resources going forward, whether it's electric vehicles or battery storage or smart thermostats or electric heat pumps is time-varying rates or solar. All of those distributed energy resources, a foundational requirement to develop those resources is to have time-varying rates. So that's why it makes sense to me, even though the current NEM tariffs are cost-effective, it makes sense to me to move solar customers to a time-of-use tariff because that's a better platform for distributed resources. Solar customers, in my experience, are not just going to do solar increasingly. Increasingly, they're going to buy electric vehicles and install electric heat pumps and take other steps to improve their homes' energy use and save money in many cases. And the platform for all of those distributed technologies is a time-varying rate structure.
If the current net energy metering tariffs are in compliance with Act 62, as you just testified, then why are you proposing a new tariff?
I think I just explained it as a platform for distributed energy resources. I just gave a lengthy answer describing why time of use rates are a platform for distributed energy resources.
And Mr. Beach must have listed in the law where the General Assembly instructed this commission to redesign the rate using a time of use rate. I actually thought they were directed to eliminate the cost shift.
Well, I think that they certainly wanted the commission to examine whether there was a cost shift and make sure that it was eliminated. I would agree with that. But I think they also wanted to look at the tariff to make sure that it's going to be an adequate vehicle to take the state into the future with respect to not only its solar program, but other types of distributed resources as well.
Beach, I wish we had talked to you sooner because we may have been able to eliminate a lot of heartache over the last few weeks. And in the statute that was debated back in 2019, if all we needed to do was shift to a time of use rate. You would agree with me, would you not, that when net metering was first introduced in South Carolina, that's precisely what the utility introduced was a time of use rate, correct?
I was somewhat involved back in 2014, but I don't remember that was the utilities proposal.
And Mr. Beach, you do understand that net energy metering has been around in South Carolina much longer than 2014, correct?
I don't know the history of it before then.
In fact, it's been around since 2007, correct?
I'll accept that, subject to check.
Okay. Now, Mr. Beach, your testimony appears to focus on the bill savings that net energy metering customers currently enjoy at the expense of the non-participating net energy metering customers. Is that correct?
Well, I would dispute your characterization that it's at the expense of non-participating ratepayers. That's not my analysis.
But non-participating ratepayers do pay more on their bill because of the current net energy metering tariff, do they not?
No, they don't.
Are you familiar with the Distributed Energy Resource Act, Mr. Beach?
I'm not sure. Is that Act 236?
Mr. Beach, in 2014, you said you were familiar with net energy metering, correct?
Well, I testified in the commission's implementation proceeding for Act 236 I believe it was in 2014.
And is it not true, Mr. Beach, there was a settlement reached in that docket? Do you remember that?
I believe that's the case, yes.
And do you recall that as part of that settlement, there is a delta between the avoided cost and the full retail rate that customers pay. You recall that?
Yes, I do recall that.
And do you recall that the delta is actually recovered through customer rates as part of the Distributed Energy Resource Act? Do you recall that?
Yes.
And do you understand that the Distributed Energy Resource Act causes a line item to appear on DESC's customers' bills in the amount of $1? Are you aware of that?
I mean, I'll accept that that's the amount.
And are you aware that within that $1, there's the difference between avoided cost and the retail rate for net metering customers that the other customers are paying who don't participate in the program?
But I don't consider that to be the cost shift, though, because it doesn't consider longer run avoided costs like avoided transmission and distribution costs or avoided CO2 costs or it certainly is some kind of short run measure of costs, but it's not a fair evaluation of the long-term benefits of distributed solar.
But you would agree with me that each month writes a check for at least $1 to pay for the cost that are incurred as a result of the Distributed Energy Resource Act, correct?
I'll agree that people pay that cost, but they're also getting benefits in the long run from reduced utility investments in infrastructure that will more than offset what they pay in that line item.
Each in your testimony, you talk about that the DESC proposed tariff will eliminate 55% of bill savings that net energy metering customers enjoy. Is that correct?
Yes.
And you also stated that the joint tariff that you're recommending approval by this commission will result in a small decrease in bill savings. Is that correct?
Yes.
And how much is that? How much is the amount of that small decrease that you have cited in your testimony?
So it's shown on table 1 of my direct testimony. The amount of the reduction depends on the size of the customer and the size of the system that they install. It's from the reduction is up to about 8% for the kind of the typical customer who installs a system to serve 90% of their usage and has 10,000 kilowatt hours of usage a year. The reduction is 6%.
Very good. So 6 to 8% depending upon the system size. Is that correct?
Well, it's more like 3% to 8% depending on the system size for the typical customers got a system that's serving 80 to 90% of their usage.
Very good. Mr. Beach, I think you testified earlier. I just want to make sure I heard it, that the cost shift that we're required to eliminate is to the greatest extent practicable, correct?
Yes.
And you stated in your server rebuttal testimony, you actually mentioned, you talk about the Duke Energy docket and the fact that there was a partial settlement. And I say partial, I don't believe all the parties have agreed to that, but if I'm wrong, you correct me, but I believe there's a partial settlement, is correct?
I think that's correct, yes.
Okay. And in fact, you point out that that Duke Energy and certain stakeholders have agreed upon a joint solar tariff, and the bill savings reductions under that joint tariff in the Duke docket is about 10%, correct?
Yes.
And you would agree with me that 10% is greater than 3 or 4 or 5 or 6 or 7 or 8%, correct?
Yes.
And Mr. Beach, isn't it true that by your own admission in your server rebuttal testimony that you have not eliminated the cost shift to the greatest extent practical as required by Act 62?
No, I would disagree with that. I think that the tariff I proposed does not have a cost shift. In fact, it probably produces a small amount of benefits for non-participating ratepayers.
Okay. Mr. Beach, do you have this is your direct testimony. I know the pagination might be a little off, so we'll work together on this. Page 20 of your direct testimony, and I'm at line 9. Just let me know when you're there.
Yeah, can you tell me what the paragraph, how it reads?
Sure, absolutely. So the question, there's a table 4, and then there's a question directly under the table that reads, what do you conclude from these results? And then you talk about your principal conclusions. Are you with me?
I'm there.
All right. And you testified earlier that there was no cost shift under the joint solar tariff that you're proposing, correct?
Yes.
Would you read paragraph 2 to the answer to that question, please?
This solar choice tariff does not cause an unreasonable cost shift to non-participating residential ratepayers, including low-income customers, as shown by the results of the utility cost test.
Right. Thank you, Mr. Beach. Now, you also talk about a gradual change for existing NEM customers in your tariff, do you not?
Are you saying that I talk about how the tariff I proposed would be a small change for new solar customers compared to the current tariff? Is that what you're referring to?
Just asking you if you advocate for a gradual change for NEM customers.
Well, I think the answer to that is yes.
And that gradual change you're talking about, that's when current NEM customers will have to transition over to a new solar choice tariff, whatever that tariff may look like, correct?
Yes, because I did also provide that before customers have to be on the time of use rate, that they should have access to at least a year of data on their time varying usage so they can understand the economics of switching to a time of use tariff.
And Mr. Beach, did you hear, were you, and I think you may not have been here, but you correct me if I'm wrong. Were you present in the virtual hearing room yesterday when Mr. Rooks was testifying?
Not when Mr. Rooks, no.
Okay, so you did not hear him talk about that the company's rolling out AMI meters across its territory as we speak?
Well, I'm aware of that, but I did not hear his testimony yesterday.
Okay, are you aware that the rollout of those AMI meters is going to be accomplished by the end of next year?
No, I'm not sure I knew exactly what the time frame was. I think that was, I had heard that it was going to be complete in 2022, so that would be consistent with that.
Okay, very good. And you understand that whatever solar choice tariff that this commission approves, that the current net energy metering customers are going to be allowed to not be required to transition to that new solar choice tariff, if they choose to do so, until as early as 2026. Do you understand that?
Yeah, I understand that there are provisions for kind of legacy treatment. Yes.
That's right. And you understand there's also a second group of customers who would actually transition to the new solar choice tariff in whatever form this commission approves until 2029. Do you understand that as well?
I believe that's correct, yes.
And is it your testimony, Mr. Beach, before this commission today that a 5-year roadmap and an 8-year roadmap is not a gradual change for those existing NEM customers?
Yeah, I don't, that's for existing NEM customers, and I don't dispute that those timeframes are a relatively gradual change for those existing customers.
Thank you, Mr. Beach. Further questions of this witness, Mr. Chairman?
All right, Commissioner questions. Commissioner Caston.
Good afternoon, Mr. Beach.
Good afternoon.
Earlier, I think it was when Attorney Cully was addressing you. I think I understood you to say that a 3 kilowatt customer would only be able to use about 40% of their demand. Why is that?
Well, a three kilowatt system would only produce enough kilowatt hours to serve about 40% of the annual kilowatt hours that are consumed by a relatively large residential customer.
Is that because the time the sun's up, or
no? It's just a function of a solar system will produce at a roughly 15 to 20% capacity factor over the course of the year. So to serve 80 or 90% of the kilowatt hours for a customer that's using like 13,000 kilowatt hours a year, you need a system that's at least 7 kilowatts. So a 3 kilowatt system would only serve about 40% of the kilowatt hours that such a larger customer like that uses over the course of the year.
So at the 7 kilowatt level, getting a little feedback there, I think. Does that allow for, I guess, a backflow into the utilities system? Does it require a 7 kilowatt system for the normal residential house to meet their demands when the sun's out? Or does that allow them to sell energy back to the utility?
Yes, a 7 kilowatt system that's serving 80 or 90% of the customer's usage, it's only generating power in the middle of the day. And during those hours in the middle of the day, it will produce more power than the customer uses, and that power will go out to the grid and serve the customer's neighbors. That's the kind of the essence of how net metering works. And it's important to recognize that when the power goes out to the grid, it doesn't go very far. It serves, as a matter of physics, it serves the neighbors. And it displaces power that the utility would have to generate in a far-off power plant and then transmit and distribute over its wires to reach those neighboring customers. And because those exports from your house serve your neighbors, the utility can avoid moving, generating power in the power plant and moving it over its wires to the neighbors. And it frees up space in the utility's wires that it can use to serve other customers. And that's why transmission and distribution costs are avoided by distributed solar. You're putting generation right down where the load is. And you need a few hundred feet of wires instead of, hundreds of miles of wires. And especially when you look at it over the long-term time horizon, that's going to save the utility money. They can take that space that's freed up in their transmission and distribution system and use it to serve new customers, to serve new loads like electric vehicles. So that's where the avoided T&D savings come from.
So if I'm understanding you correctly, you're saying that, I guess because of resistance and whatever else, that electricity can only go just so far through that wire and then it goes somewhere close by. Is that what I'm understanding?
Absolutely. I mean, the only situation where that would not be true is if everybody on the street had solar, and there's some places in Hawaii, for example, that have very high solar penetration, where that happens, and you power ends up flowing back up the distribution system. It reverses the flow on the distribution system. But that's only in situations where you have extremely high penetrations of solar. It's not the situation in South Carolina. So it's very important to recognize that fact, because that explains why distributed solar reduces transmission and distribution costs, which Dominion has not considered in this case.
Well, with that in mind, I think I also understood you to say, I think ORS and Dominion failed to recognize reduced CO2 and avoided cost, and other things. Are you aware that avoided cost was established in a previous docket, 2019-184-E?
I will accept that the commission has adopted avoided costs in other dockets. I certainly thought that it was the purpose of this docket and the methodology docket to reevaluate avoided costs for distributed solar.
Well, I guess someone will have to clarify that for me, but that's not my understanding. What I think I do understand is that ORS and Dominion are required to use the established avoided cost. Is that correct?
That's not my understanding, but my understanding was that this case the commission was going to look at the costs and benefits of distributed solar in evaluating new solar choice tariffs. And if you're telling me that actually the benefits were decided somewhere else, that doesn't seem to me to be consistent with the statute.
No, I'm not saying that. I'm not trying to imply that. I'm just saying that when you do look at fairly allocating costs and benefits, and what, as each witness that I hear, I'm still trying to download, process, and expand my understanding. And what I think I'm understanding more and more, whether I agree or understand the physics of how far electricity can go before it dissipates out or disappears in an electrical line, I don't know. But it appears that the argument or the discussion is about providing that rooftop solar.
Commissioner Caston,
yes.
I hate to interrupt you, sir, but I don't know if someone's mic is not muted or we hear a dog barking in the background.
I apologize. That's my dog. I'll try to mute until the commissioner's done with his question.
And if you would also, Mr. Beach, cut your mic down a tad. Thank you. Commissioner Caston?
Anyway, I think what I'm hearing as either part of the argument or the argument is a desire for rooftop to have as much excess capacity as they can to push it back into the grid for the opportunity to sell it at a retail rate. Now, one witness was saying that this is banking, and then when they need it at night, okay, they've put more in than they took out. And I think I understood you to say that was one of the reasons, or maybe the main reason, to have excess capacity to push back out into the grid. And are we trying to reduce the cost of the person, company, or whatever that has rooftop solar so they can supply their own solar, whether they have storage or not? Or are we trying to have mini power plants that can sell back to the grid? Because if that is the case, then I would probably want to sell it at retail too. But if the avoided cost is around that 4.5 cent, if that's accurate, it must be, that's what we said. And the retail rate is that 11.6 cent. That cost is going to someone. And that avoided cost, or that subsidization cost shift, whatever you want to call it, maybe we can debate the numbers, but that sounds real to me. So oversizing so we can put it back into the grid to sell it at retail rate, that's what I'm kind of understanding this debate is about. And somehow I'm not sure that necessarily should be the debate. Am I missing something? Have I misunderstood something or mischaracterized something?
No, Commissioner, I think you're understanding the debate. The difference, the difference between my testimony and Dominion's testimony is I don't agree with the 4.5 cents of avoided costs for the reasons that I laid out in my rebuttal testimony in the methodology case, which has been included in the record in this case. I think that the avoided costs are more like 14 cents, and they're higher than the retail rate. And that's why there's no cost shift. So, if the avoided costs are really just 4.5 cents, then you have reason to be concerned about a cost shift. But I don't think that the avoided costs are that low, especially when you consider avoided transmission and distribution costs and avoided carbon compliance costs and things like that. You find that the avoided costs are much closer to and maybe even above the retail rate. And I think you would then agree with me that in that case, there's no cost shift concern. So that's what you really, I think, need to evaluate in this case.
Okay. Well, let me ask this, and I might be getting way out of my zone of comfort understanding, or maybe in the weeds. But as I hear that, and as I think about that, and I think about, okay, we have this, let's say, solar farm out here. I don't know what it produces, but it produces energy. And I heard someone mention purple, I think, earlier, maybe yesterday, possibly today, I don't know. And the requirement that the adjacent utility or the utility has to purchase it. And I'm not sure I can speak to all of that. But if I had this farm, solar farm, that was producing X kilowatts, and my retail rate is 11.6 cents per kilowatt hour, whatever, would it make sense for that utility to purchase that energy at retail rate? That's why, as I understand it, there are things like avoided cost, because that utility has invested significant capital over the years to put in infrastructure, plants, to serve this area, whatever their defined area is. And it would not be sustainable for any entity if you could come in, produce electricity or water or whatever it is, just come in, I'm going to set one up here and sell it back to you at your cost or higher. Now, I could be missing something. I may be misunderstanding this whole thing. That's a possibility. But that's kind of where I see this, just on a smaller scale. Does that make sense? Am I misunderstanding something?
Commissioner, that's an important point that you've raised. There's a real difference between a rooftop solar installation and a utility scale solar farm that such as you just mentioned. The solar farm is located out in the someplace rural, a long way from the load center, and that solar generation has to be transmitted and distributed over the utilities wires to get to customers. And whereas if I produce solar on my rooftop, half of the solar never even touches the grid and just is used to serve the loads in my own house. And the other half may go out to the grid in the middle of the day when I have excess, but that'll serve my neighbors that are 100 feet away and free up space in the utilities upstream T&D system that other people can use. So the rooftop solar saves the utilities transmission and distribution costs, whereas the remotely located solar farm, it might require the utility to upgrade a transmission line in order to get that power to the load center. So there's a real, it's like real estate, location, location, location. There is a difference in the value of these resources depending on where they're located.
I agree. And I don't know if you caught the previous testimony. I think Mr. Zimmerman. But one of the things that I mentioned I'd thought about is, regardless of where it is in the system, that if I'm putting it back in the system and I'm banking it, I don't think there's really a bank per se. It's like you say, it's going into the grid, maybe in use somewhere else. But in essence, from the utility perspective, at least the way I'm thinking about it, is I'm relying on that utility to supply my needs when I can't produce it. Is that true?
Yes, that's right. But that's the way net metering works. I mean, the simple explanation for net metering is that when your house needs electricity, you run the meter forward, right? And then when your solar panels have excess electricity, the power goes out to the grid and it runs the meter backwards. So at night, when the sun's not shining and your solar panels aren't producing anything, you're pulling power off the grid and you're running the meter forward. And you pay for all of that electricity at the utility's regular retail rate when the meter runs forward, just like any other residential customer. Where things get complicated is the part in the middle of the day where you're shipping excess power out to the grid and the meter's running backwards. And the question that commissions like this one all across the country struggle with is, what's the value of that power that's going out to the grid? What is it worth? And but in trying to and the retail rate is at best rough justice. What we're trying to determine is how close is the retail rate to the value of that exported power? And how should we adjust that retail rate so that that exported power is fairly valued for both the solar customer and for non-participating ratepayers? And in doing that, it is very important to take location into account and to consider the fact that when the power is exported to the grid, it only travels a short distance before it's consumed by neighboring customers. And that allows the utility over time to save money on its transmission and distribution system. And those avoided T&D costs need to be considered in the equation here, or it's not a fair comparison. And that's my number one concern with Dominion's methodology. In the Duke case, where Duke does value avoided T&D, and their avoided costs are significantly higher than 4.5 cents, we were able to reach an agreement that I think would be a win-win for everybody. But that's kind of the essential issue that you need to wrestle with.
Understand the meter going, depending on which way it's flowing, is whether I'm needing it or whether I'm not needing it. I get it. And I won't belabor the point, but when I do think about the utility perspective, and I'm not saying this, I'm not trying to argue Dominion's case at all. I'm just simply thinking the way I used to think when I did this in another life. That infrastructure is there to provide 365-day, 24-hour service, period. Whether it's needed or not, in anticipation of need. So if it's flowing back to me and I'm paying for it at my cost or retail cost, my retail cost, if that's what I'm paying for it, there's no way that is recovering the cost that I have in that system, that all my existing customers have paid for years or now to pay for that existing infrastructure, in my opinion. At least that's the way we looked at it, where I formerly worked. And I'm struggling with that because that's, to me, fairly basic. But I'm not here to debate you. You have your beliefs, and I understand it, and I appreciate your time. I really do. Thank you very much.
Commissioner questions for this witness.
Mr. Chairman.
Vice Chair Belzer.
Good afternoon, Mr. Beach. Thank you for your testimony today.
Thank you. Appreciate it.
Mr. Beach, I just wanted some clarification on the rates that you used in your study, in your calculations. You stated that you used the time of use rate 5. Did you use the current rates or the rates proposed in the Dominion rate case?
I believe we used the current rates.
Okay. And I think you used a placeholder for the BFC of $13.50. Is that correct?
Yes, that's right. We didn't know how that issue was going to come out, so we kind of split the difference between the parties in that case. I mean, I guess my recommendation would be to use whatever you end up adopting in that case.
But that's not going to be concluded until after this tariff needs to be in place.
Yeah, if that's an issue, I guess we would propose to use the 1350, subject to revision after that case is decided.
Okay, thank you very much.
You bet.
Commissioner, questions for this witness?
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. Mr. Beach, you said in your evaluation that it would take 20 years to recoup the investment.
Yes, that's right.
And what is the, I've been trying to get a good answer on it. What's the lifespan of a typical solar system that someone installs?
I think generally that sort of at this point, the industry standard is 25 years.
25?
25, yes.
Okay. So it would be a recurring thing to start over at about the same time that the investment's recouped.
Well, it's important to recognize, Commissioner, that that's just the return of your investment. It's not does not include a return on your investment. So something that has a 20-year simple payback, it is equivalent to, like, if it's a 25-year resource, it's like you're going to have a negligible return on your investment. You may get your original money back, but you would have done much better if you'd put the money somewhere else.
Okay. And your calculation, that included the tax benefits that exist presently.
That's correct. It also, but that calculation also does not include if you have to finance the system and you're paying interest.
Yeah.
That would extend, it would make it even a less attractive proposition.
Okay. Cash is king.
Absolutely. Money has value over time.
Okay. Thank you very much. That's all I have, Mr. Chairman.
Commissioner, questions for this witness? Sounds like we may be ready to go. All right, I got a couple of questions for you, sir. During the company's case, we talked a lot about cost shift, and we talked about how the statute speaks to the commission's responsibility to eliminate any cost shift to the greatest extent practicable. Now, in you're aware of that, right?
Yes.
Okay. And based on your testimony, it seems to me that you don't believe the solar industry, and I'm using that in a broad sense, would survive in its current form and definitely wouldn't experience any growth if Dominion's tariff or ORS's tariff is implemented.
I would agree with that.
How long would it take for the business to go bust if either one of those tariffs are implemented?
Well, with the Dominion tariff, it's possible that there might be a business installing very small systems on larger customers. But that would be a much smaller industry than exists today. In terms of how soon that would happen, the solar industry it's kind of like, it's becoming like the heating and ventilating industry or appliances. It depends on, a continual stream of projects, and projects are developed over a relatively short period. So I think you would see the impacts fairly quickly if you approved either of those tariffs.
Do you not think the General Assembly considered that there may be some change in the market considering that the statute requires us to eliminate to the greatest extent practicable, subsidization or cost shift?
Well, I certainly think that the General Assembly wanted you to look at that issue. And that's absolutely appropriate to consider the impact of this technology on non-participating ratepayers. My reading of Act 62 is they wanted you to look at it with a fresh set of eyes and considering all of the costs and all of the benefits of this technology and determine what those benefits and costs are and then determine whether there's a cost shift. I mean, from what I've heard is that the Dominion seems to think that the benefit side has already been set and that we're not going to look at that afresh in this case. And I don't read Act 62 that way. I think it asked the commission to take a new look at both sides of the equation, not just the cost side, but the benefit side too, and to establish a new solar choice tariff looking at both sides of the equation, not just at one side.
Well, in all fairness, it's not just Dominion. In fact, ORS suggests deeper cuts to address deeper cuts in the savings or benefits experienced by new solar users than the company does. Is that not true?
That's right. And again, they did not look, even though their witness, Mr. Horry, in his methodology testimony, recommended that the commission look at avoided transmission and distribution costs in this proceeding in developing new solar choice tariffs. ORS decided not to, and they have not looked at the avoided cost side of the equation. And so given that they haven't looked at avoided costs and they haven't looked at benefits, that kind of led them to the conclusion that they came to.
Does it not cause you some concern or maybe make you pause and reconsider your analysis when the agency charged with looking out for the public interest suggests readjusting or suggests the most aggressive form of adjustment to the current NEM rate, that maybe there's an issue impacting the public?
You know, I don't want to speculate on what ORS's views on rooftop solar are. They did not file, frankly, they didn't file testimony on the benefits. They simply looked at the design of the tariff, taking the avoided costs as a given, and they didn't try to relook at that. I don't know why they didn't do that. I think you might want to ask them.
Do you think that at some point, regardless of whether your suggested tariff is implemented or ORS's or the company's suggested tariff is implemented, at some point the cost shift needs to be completely eliminated?
You know, I agree that it's important not to have a cost shift. And I think that the cost shift, that there really isn't a cost shift in South Carolina when you look at all of the benefits and you go beyond just looking at avoided energy and a little bit of avoided generation capacity costs. If you add in other avoided costs like transmission and distribution, and you add in avoided carbon costs, you're going to find that there isn't a cost shift. I mean, that's my opinion. And I think one thing that's revealing, Commissioner, in Mr. Horry's testimony for ORS has in one of the exhibits, they showed 23 different value of solar studies that have been done all across the country. And you'll see in those value of solar, some of which my firm has done, some of which E3, Mr. Horry's firm, has done, some of which GuideStar has done. Almost all those studies have multiple benefits that have been quantified, not just avoided energy and avoided generation capacity. I think I looked at those 23 studies, and 22 of the 20, this is in my surrebuttal testimony, 22 out of the 23 studies quantified avoided transmission and distribution benefits. The only study that didn't was one of Hawaii. And as you know, Hawaii is a bunch of islands, and they don't have much of a T&D system because there are no power lines between the islands. So every other study in the US that has looked at avoided costs for distributed solar has considered avoided T&D. In South Carolina, it has not yet been considered. My testimony, if there's one point from my testimony, is that you need to do that. Otherwise, you're heading down the road that Nevada went down. Nevada didn't look at avoided T&D either in its case, and that was a major reason why they had the debacle there. So, that's what the situation is.
Well, I can tell you one thing. We've had enough debacles. We don't need any more debacles. So we're trying to get this right so we won't have to have another debacle. Let me ask you this. If this is a hypothetical, of course, but say Joe Ratepayer in South Carolina finds out that about 80 cents or so, somewhere between 50 to 80 cents of their bill, his bill, her bill, is to pay for residential rooftop solar, commercial solar, whatever it may be, solar deployment. How would you explain to them the benefits to them? Why are they paying that approximate dollar for solar energy when they don't reap any direct benefits? Or do you believe that they do, the individual?
Yeah, I believe that they do, Commissioner. That's the essential difference between Dominion and me in this case, is that I believe they do. It's very easy to calculate that 80 cents by looking at the revenues that Dominion might have realized if somebody hadn't put solar on their roof. That's really easy to calculate. But what is more difficult to calculate is what are the benefits to the utility of customers producing their own power on their own premises using their own private capital, and what are those benefits over 25 years? Those benefits are things like the utility is not going to have to string more wires across the state to move power from central power plants to load centers because customers are producing power on their own roofs. And that's a benefit that you don't see immediately, but you will see over the life of the solar system. Here in California, where we have, which is the largest solar market in the country, over the last few years, the utilities have canceled $3 billion of transmission investments due to a combination of rooftop solar and energy efficiency. These were projects that they had previously planned, but the demand didn't grow because customers are either using energy more efficiently or putting solar on their rooftops. And those avoided costs are difficult to see because they only happen over time and in the long run. Occasionally, things like the $3 billion of canceled projects emerges, but avoided costs they're counterfactual. They're costs that are never incurred, so they are difficult to estimate. But they are real, And most utilities in the U.S. Calculate their marginal or avoided transmission and distribution costs. And, Dominion should do so in this case.
Maybe they should, maybe they shouldn't. I don't know. It's up to them to present their case, and they've made it pretty clear where they stand. My concern is that your answer will probably really confuse Joe ratepayer, because it sort of confused me. It's very abstract, and you admitted as much. But I think that's the difficulty that we're dealing with here. The argument is so abstract that it's hard to find a direct benefit for the individual. There may be some collective benefit, but for the individual who's on a fixed income, who could really, and you may not know anybody like this, but we have a lot of public hearings here, and we hear a lot about the everyday person and what they're going through and how difficult it is to pay their bill. Telling them that over the long run, over 25 years, that they will reap some abstract benefit when today they're hungry is probably going to be difficult for them to understand. Would you not agree with that?
Commissioner, I certainly agree that these are complex, difficult issues, but we have to grapple with them, and just because it's a difficult calculation doesn't mean we should assign it a value of 0.
Where can we go? Not to cut you off, but where can we go to get that calculation? Who can give it to us?
The utility could do it. I mean, my rebuttal testimony in the methodology docket, which is an attachment to my testimony in this docket, has a complete calculation of Dominion's avoided transmission and distribution costs. It's in the record of this docket.
All right. Thank you, sir.
So I would.
Oh, I'm sorry. I didn't mean to cut you off. Go ahead and finish your.
No, that's all right. I'm done.
Okay. All right. Redirect.
Thank you, Mr. Chairman. No redirect for this witness.
All right, ladies and gentlemen. We are going to end for today. Let me make a few announcements before you all sign off and we actually recess. We're going to start in the morning at 9. Monday morning at Monday morning at 9 o'clock. No, I'm confusing myself. Monday morning at 10 o'clock. We will start Monday morning at 10 o'clock. If we need to go into Tuesday morning, we will start at 9 o'clock. And I would ask that you prepare to stay on both Monday and Tuesday until 8 p.m. All right, we're in recess until Monday at 10 a.m. Thank you.
Chairman Williams, Taylor Spear on behalf of Alder Energy, I appreciate your consideration and my time conflict. Thank you.
No problem. We're all in it together.
Thank you.